Good morning, everyone. Welcome to the second day of our meeting of the Joint Judiciary Committee. It's good to see everyone. Appreciated all the work yesterday and appreciated the co-chairman shepherding us through. And today we've got a very, very busy agenda. I just want to open by reminding everyone that we expect a high level of decorum in our legislative meetings. The way we operate is that we expect courtesy and civility, and we expect everyone who wants to testify on a particular topic. We welcome that. That's part of why we're here. But we expect folks to go through the chair with their comments. So please abide by some decorum today, and we'll get a lot of good work done. We're here to listen and learn, and that's the way the process works. So, Mr. Co-Chairman, any comments before we start the day?
Thank you, Mr. Co-Chairman. I too want to welcome everyone this morning. We do have a very packed agenda. We have lots of people signed up to testify. So it is conceivable that we may have to have some time limits. That's not to diminish the value of testimony at all, but they're practical realities. We have lots of things on the agenda. So if someone has already said what you're intending to testify about, you might think twice about whether or not you need to go to the microphone and add to that discussion. Likewise, try not to be redundant with one another. Focus on the bill drafts that we have before us rather than the topic generally. That's what we do in the second meeting of the joint interim meetings, is we go through the bill drafts and we try to improve the language in the bill draft. So if you folks would focus on those things, I think we'll have a very productive day, and look forward to the testimony.
Okay, thank you, Mr. Co-Chairman. Today is mostly devoted to law enforcement issues, and let's get started this morning. We will take up controlled substance revisions, along with a little bit later this morning, sex offender registry, and then peace officer public records. Let's get started with draft 54, Controlled Substances Act, substance type amendments. And Brian, if you could walk us through the bill, please.
Yep, Mr. Chairman, this is working draft 0.513-01 in the meeting materials. This is a bill draft that the committee requested at the April meeting after hearing testimony from the Attorney General. The committee's direction was to work with the Attorney General's office on language, and this draft reflects their input. This bill draft eliminates the form of a controlled substance as an element of the offense of unlawful possession of a controlled substance, clarifies that possessing a detectable amount of specified controlled substances are prohibited. So on the bottom of page 2 is just a conforming amendment for language in 35.7.1031C intro. And then moving on to page 3, line 2, any person who possesses a controlled substance and has a schedule 1, 2, or 3, or 4 controlled substance in an amount of less than 3 grams is guilty of a misdemeanor punishable by imprisonment for not more than 12 months, a fine up to $1,000, or both. And Mr. Chairman, members of the committee, I would also mention that generally, even though the form of the substance has been deleted or stricken from statute, the penalties for possessing these amounts have not changed. I think there may be a couple of exceptions that the Attorney General's office may wish to explain. But then page 3, line 15, for a third or subsequent offense of possessing an amount less than 3 grams, it would be a felony up to 5 years and a fine up to $5,000. Page 3, line 22, this concerns methamphetamine or another controlled substance that is in Schedule 1 or 2, that is a narcotic drug, and the amount is 3 grams or more. That would be a felony up to 7 years and a fine up to $15,000. Page 4, line 7 is LSD in an amount less than 0.3 grams. For a first or second conviction, it's a misdemeanor. For a third or subsequent offense, it's a felony, 5 years and a fine up to $5,000. Page 5, line 2 is LSD in an amount more than 0.3 of a gram, and that's 7 years and $15,000 fine. Page 5, line 9 is marijuana or THC in an amount of less than 3 ounces. A first or second offense is a misdemeanor, and then page 5, line 20, a third or subsequent offense is the 5-year felony. Page 6, line 4 is marijuana in an amount of 3 ounces or more. That is a felony up to 5 years and a fine up to $10,000. Page 6, line 11 is any substance that's classified in Schedules 1, 2, or 3, not otherwise listed in this subsection, in an amount of 3 grams or more is a felony, 5 years, and a fine up to $10,000. Page 6, line 19 is a Schedule 4 substance. More than 3 grams is a felony up to 2 years and a fine up to $2,500. And then page 7, line 4 is a Schedule 5 substance in any amount is a misdemeanor, so up to 12 months and a fine up to $1,000. The staff comment just includes 35.7.1031D for reference. That concerns how packaging and cutting materials are calculated. Page 7, line 29 repeals 1031C1 through 5. And these subsections provided the penalty for possessing a controlled substance. They've been reorganized in this bill draft. Notably here, the subparagraphs in C1 that designated plant form, solid form, crack, and so forth have also been repealed. And that language you can see are on pages 8, 9, and 9. The bill draft will be effective July 1, 2024. With that, Mr. Chairman, I stand for questions.
Questions? Representative Oakley.
Thank you, Mr. Chairman. Thank you, Mr. Fuller. My question, the first thing that the LSD, page 4, line 7. So it seems to me, so I'm seeing the 0.3 of a gram, which I also think of with like liquid methamphetamine, is the weight like in current statute being 0.3 of a gram for like something liquid. Am I missing that as far as what the weight would be for that?
Yeah, so
Go
Mr.
ahead.
Chairman, Representative Oakley, currently liquid, so an amount in liquid form would be no more than 0.3 of a gram. So that's the current law. That's on page 9, the top. This would eliminate that. And so for methamphetamine, that would actually be under page 3, line 22. And that's 3 grams or more of methamphetamine would be a felony.
Follow up.
Further questions?
Yeah, follow up.
Oh, absolutely. Go ahead, Representative.
Thank you. So, and I guess I'm just trying to make sure that I don't, like the 0.3 of a gram for the liquid, I guess I think it would be important to keep, not make it not change it from 0.3 of a gram of liquid meth to 3 grams of it. So I guess, and I know there's some wiggle room trying to figure out how to switching it from this form concept. But that's not something substantively. Am I missing it? You're looking at
So-
it confusedly.
Go ahead, Brian.
Yep, Mr. Chairman, I'm not sure the amount has changed. I think the threshold for the liquid form currently is 0.3. And then here, so page 4, the methamphetamine, I don't think, yeah, or 3 grams or more. Yeah, so that would be, yeah.
Yeah, I would look at keeping that the same, so adding it more to like page 4, but I just, page 4, line 7. Anyway, we can discuss it. I just want to make sure that I'm seeing that right. This would only have LSD as 0.3 of a gram and not those other liquid forms, which I would be leery of making that.
Any other questions for Mr. Fuller? Okay, let's hear from the Attorney General's office. Good morning, everyone. Good to have you here. Thanks for joining us. Take it away and tell us about this bill.
Good morning, Mr. Chairman, Senators, Representatives. My name is Kelsey Singleton. I'm with the Wyoming Attorney General's Office, and I represent the Division of Criminal Investigation. Before I begin, I'd just like my counterparts here to introduce themselves.
Good morning, Matt Waldock. I'm a commander with the Wyoming Division of Criminal Investigation.
Good morning, I'm Sarah Barrett. I'm with the Wyoming State Crime Lab. I'm in charge of the drug chemistry section.
Good morning, my name is Scott McWilliams, and I'm with the Wyoming Division of Criminal Investigation as the Deputy Director in charge of the State Crime Lab.
Okay, thank you very much. Please continue and walk us through this bill from your perspective, if you would.
Thank you, Mr. Chairman. First, I'd like to thank LSO for the time and effort to draft the proposed bills to address the Attorney General's concerns. If you recall from the last meeting, our chief concern was that there are several controlled substances that the crime lab regularly sees that don't fit within one of the forms that was listed in the Controlled Substances Act. And so this amendment is hoping to rectify that issue. I can certainly address the legal issues. I'll leave the chemistry questions to Ms. Barrett. First, for the substances amendment, it does address all of DCI's concerns. Representative Oakley, you did have a specific question with regard to liquid methamphetamine, and that was one that we did recognize. It would change from 0.3 of a gram to 3 grams. We did address this with the crime lab. Oftentimes they see diluting agents with the methamphetamine, and so from their perspective, the concern was minimal in that respect because they have other substances that are going along with the methamphetamine, that often it is above that 3-gram threshold for what we would consider a felony amount of methamphetamine. So that certainly is something that would change under the amendment, but something that wasn't a significant concern to DCI. Additionally, there is another one that we wanted to point out that would change. If I'm saying this correctly, psilocybin mushrooms is a plant material. And so that would change from 3 grams for a felony versus 3 ounces as it was before. Again, not a concern given what the crime lab has normally seen in these cases. But you are correct in that the threshold would change for 3 grams for liquid methamphetamine.
Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So my question has to do with the different forms of cannabis products that we see. And it seems to me that 3 grams of plant material compared to 3 grams of some of the other forms, wax and shatter and so forth, in terms of dosage units, or 3 ounces of shatter is a lot more dosage than 3 ounces of plant material. So can you describe whether that's acceptable to DCI, or do we need to make some changes in this?
Mr. Chairman, that's another good point to make. I'll let Ms. Barrett kind of explain the chemistry side of it, as I don't think I will eloquently do so. But I do believe that the concentration is more the concern, and the concentration could come in a variety of forms. And so I don't think we rectify your concern with just saying wax should be differentiated from shatter versus plant, but I'll let Ms. Barrett elaborate.
And it is Kelsey, right?
It is.
And could you state your last name again, Kelsey, so
Yes.
everyone gets that?
Yes, it's Kelsey Singleton.
Okay, thank you. Go ahead, Ms. Barrett. Good
Mr.
morning.
Chairman, good morning. Representative Washit. So currently it would, the
Tara,
way
can you
it's.
get really close to the microphone for us, please?
Yes,
Thanks.
sir. The way that the bill is currently written, it would put THC shatter or wax in the 3-ounce felony level. That's about 85 grams. So I'm not sure what a vape cartridge typically weighs, something around 1 gram if it's full potentially, but we see them in most of the time they're partially full or almost empty. So I would say when we receive a vape cartridge at the crime laboratory, oftentimes it's under 1 gram. And so you would be talking about potentially 85 vape cartridges if that helps you compare how much going from grams to ounces is. And 3 ounces would be about 85 potentially cartridges.
Follow up, Mr. Co-Chairman?
I think I'll ponder that for a bit. Thank you.
Questions, committee? Okay. Ladies, gentlemen, any other testimony on this bill? What else can you tell us?
I would like to point out one other difference from the current statute to this bill, and that's with cocaine base or crack cocaine. The previous threshold was 1/2 gram, 0.5 grams, and this would move that to 3 grams for felony.
Okay. Committee, are we good? Let's, go ahead, Representative Oakley.
Thank you, Mr. Co-Chair, and thank you, Ms. Barrett. And I think you answered this, but, and I'd be interested in changing it back, I'll just be honest, but to talk about it. So, but the liquid, since this bill switches it just to LSD, I'd be interested in taking the methamphetamine back. Is there another type of liquid that we're missing? Like you know what I mean, that the 3/10 to, that should be listed out.
If you, Chairman,
Go ahead.
Representative Oakley, if you're going to want to consider methamphetamine and dropping that back to 0.3 gram, I would also consider heroin in liquid form. That is a Schedule I controlled substance, where methamphetamine is a Schedule II. And so that would be one, I think, if you're wanting to do that, you should also consider.
So, Ms. Barrett, you could really help me and possibly folks here and streaming in, just to tell us exactly what the differences are from this bill from the current statute. Can you run us down through that one more time, just
Okay.
so I'm fully understanding of what this bill does?
Okay. So we were trying to remove the form aspect because there are, as Kelsey mentioned earlier, there are forms of controlled substances we see that don't neatly fit into what was prescribed in the current statute. So looking at removing the forms issue, we actually followed what Idaho does, and they look at what type of controlled substance it is. And so that's where we went to Schedules 1, 2, 3. At 3, I'll have to refresh my memory on it. But Schedules 1, 2, 3, and 4, less than 3 grams being a misdemeanor. We took the same weight that's currently in statute for powders and crystalline material, which is 3 grams. We pulled marijuana and THC out of that because currently in Wyoming statute, that is Schedule I. So we pulled that out and said Schedules 1, 2, 3, or 4 narcotic, excuse me. And those and the penalties, I believe, stayed the same. I didn't focus so much on the penalties when I was reviewing this. And then we felt like 3 grams of LSD was quite a bit when you consider dosage unit. It's in the microdose level. And so we left 0.3 grams specifically for LSD. Let me go through here. So LSD is its own case, marijuana and THC is its own case also, and we left the 3 ounce level because that's what it was for plant material.
So essentially what you're saying is on the marijuana level, we've essentially left things alone.
Yes, and we are actually treating it a little differently than we would other Schedule I controlled substances with this current bill.
Okay.
And then, so we basically looked at it from what kind of drug, what schedule is it, and then created weight thresholds, which actually we didn't create. They were already in our current statute. We just copied, 3 grams, 0.3 grams for LSD, 3 ounces for plant material.
Gotcha.
Like Kelsey mentioned, the differences I noticed were in the mushrooms, so psilocybin, psilocin mushrooms. Although they're not really a plant material, I think they were being treated like a plant material because they were closest to that form. And so I believe previously in the court system, it was being charged 3 ounces was a felony. And with this bill, that would change to 3 grams. So that's change number 1 we noticed. Number 2, the THC products, so vape cartridges and edibles, those would be felony at 3 ounces currently. And then crack cocaine or cocaine base is another term for it, would move from 0.5 grams to 3 grams. And that would be match up with cocaine now, if that makes sense. So before we were distinguishing between crack cocaine and cocaine, regular cocaine, and they had different weight thresholds. And so now we're just making them even. And we're saying it's 3 grams for felony.
So for future reference, Ms. Barrett, it would really be helpful if, when you get back to the office, if you would share that information with the committee, it would really be helpful to us, okay?
I will do that, sir.
Thank you so much, and Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. This is for Commander Waldock. Still trying to wrap my head around this distinction in the cannabis products. If a trafficker sells 3 ounces of wax or shatter, and another trafficker sells 3 ounces of plant material, which one generates, are they comparable in terms of the value on trafficking, the dollar?
Chairman Washit, as far as dosage unit, absolutely not. Shatter's gonna typically, I'd have to have Ms. Barrett talk about that, but they're definitely a higher dosage unit for shatter or for wax versus a plant material. I think the important part of this is we never have had, because they differentiate shatter and wax, different prosecutors look at that differently. And I think it's just important that we have a weight that we can go by so we can differentiate charging.
Go ahead, follow up.
I guess my concern is I don't want to incentivize traffickers to move in the wax and shatter type forms if that's a more profitable, less risky area in which to, sell your product. I'm not sure that we come out ahead as a community to have more wax and shatter and less plant material being trafficked out there. You see my concern?
Mr. Waldock, go ahead.
Chairman Washit, I absolutely see your concern in that. I believe the way this bill reads, it doesn't differentiate those two. The shatter, the wax versus the plant material. But obviously, we're going to follow law, whichever one's passed or whichever one's there.
Let's go to Senator Case first, and then I'll come back to you, Representative Oakley, okay? Senator Case.
Thank you, Mr. Chairman. I've been trying to struggle, and maybe this has already been answered, but I'm trying to understand when we go from a solid form to a liquid form, and the amount the weight goes up. I take it that's to account for any kind of diluting agent in the weight or the liquid. And then I'm wondering if it's kind of arbitrary that you can have the solid form and you could dissolve it in a liquid, and then you could have less than 3 grams you dissolve it into, or you could have a gallon of water that weighs 8 pounds and dissolve it into. Does that change the crime with respect to what's doing it? And Mr. Chairman, just to follow up, it kind of goes back to our discussion a couple of years back of edibles, which I don't think we've ever fixed. Because, when you throw something in, something that's edible, there's this dilution factor. And we had proposed bills that were trying to look at the weight of the edibles, but not, and several of us pushed back on that because they weren't looking at the weight of the controlled substance or the amount of controlled substance. So is this similar, or am I missing something? And I apologize if I missed it.
Yeah, Senator, I remember that was a difficult debate, and I'm looking at Ms. Barrett, but it could be, Kelsey, it could be you. Who wants to follow up on the senator's questions? Go ahead.
Representative, currently, if a person had 2 grams of meth, which is not a felony weight currently, and they put that into, say, a toilet of water, now that becomes a felony weight currently. So this bill actually corrects that. And so it would be 3 grams across the board, no matter the form.
Okay, follow up. Go ahead, Senator.
is it 3 grams of the substance within the liquid? Or is it 3 grams including the liquid? So
Ms. Barrett?
that, so I don't think we've solved it if it's the latter.
It would be including the cutting agent, diluent, carrier element, which is currently in statute. So that part of the statute does not change with this bill draft.
Mr. Chairman, just one
Follow
last
up,
thing.
Senator
So,
Case.
well, I'm not sure that this fixes what we want. It tells me that you take something that has a lesser penalty in a solid form, in a pure form, then you put it in something, you dilute it with something that's not itself illegal, and then it becomes a higher penalty? That's what it sounds like you just said to me. And so I know I heard you also say we're trying to get away from that, but your words were confusing to me.
Can you clarify? Either one, go ahead.
Chairman,
Singleton?
I'll
go
try
ahead.
one more time. Currently, right now, if an individual had 2 grams of solid meth, and that is not a felony, if he dumps it into a liquid now, it becomes a felony.
Okay, how does it change with this bill, Mr. Chairman? Is it,
Mr. Chairman.
Go ahead, Mr. Fuller.
Yeah, Mr. Chairman, Senator Case, I don't think it does. And the language, so it's the staff comment on page 7 is the language that I think you're honing in on. And so the situation, Mr. Chairman, that's been described, I don't think that changes with this bill draft.
so why are we doing this?
So let's go to Representative Oakley and ponder, Mr. Fuller, thank you. Go ahead, Representative.
So, and I mean, for discussion, thank you, Mr. Chairman, for both Mr. Fuller, Ms. Barrett. So I think what Ms. Barrett was getting at is, in the end, it still does include, because there just is a reality to the flip side. Where you're going would be if they dumped it in water, then it doesn't become illegal. And we're not going to allow for that sort of a possibility, right? Then you just dump it in the toilet and you don't get convicted. But I also think, and this happens in these discussions, and it's fine for the academic portion of it, but the reality is what we find is somebody who's shooting up methamphetamine into their veins. The idea of that it's in a toilet, the reality is then they probably are going to get away with it, and that's okay. But what conduct are we trying to prohibit? And the reality is, when you've got the syringe, you're injecting it. And I think what Ms. Barrett was getting at is this does become much more liberal, if you will, in that now it's 3 grams instead of 0.3 of a gram. So while Mr. Fuller's saying, and is correct, it still does include the dilutants. But now you have to have 3 grams of it instead of 0.3 of a gram, which is what that's how they're trying to solve what you were getting at, is it is significantly more, which takes into account then some diluting agents rather than 0.3 of including your toilet water. Now it's 3 grams.
Senator Case.
Mr. Chairman, I appreciate the difficulties law enforcement has and prosecutors have, but I'm just like, what difference does it make? I realize you're talking about stuff you shoot up, and maybe you should look at the action there and stuff. But whether I put it in a glass of water, and I'm thinking of something you could put in a glass of water and drink, I put it in an ounce of water and drink it, or I put it in a gallon of water. If it's the same amount of material initially, you're possessing the same amount, and the form is now changed. Why does the crime change?
Let's go to the co-chairman. Maybe he's got some input there.
Thank you, Mr. Co-Chairman. I think Commander Waldock can probably chime in on this as well. From the practical side, when we're seizing this material on the street, and it comes with a carrier or a dilutant, trying to decide at that point how much is water and how much is methamphetamine becomes problematic in terms of charging the crime. Am I right? So part of the reason we classify these drugs with the carrier is because it's all mixed together at the time we seize it and at the time we're admitting it in court. Can you elaborate on that a little bit? Maybe make it clear?
Mr. Waldock, please enlighten.
Chairman Washit, I'll go back to, I've been involved in narcotics now for right around 30 years. Years ago, we used to see methamphetamine that was 15 to 20% pure. The rest of it was binders. And now we're seeing stuff in the 80s to 90%. My point being is that the methamphetamine is purer than it used to be, but it always carries some sort of a binder. And I'm sure Ms. Barrett can expand on that, but they always have some sort of a binder in them. In addition to that, we're also seeing a lot of liquid methamphetamine. It's being shipped in a liquid form. So having an actual weight of the liquid methamphetamine would be super important.
So, Ms. Barrett, I think where the senator was going is a question in my mind too. Do we even have the ability to determine out of a gallon of water exactly how much content of something like methamphetamine can we even determine whether or not that was initially 2 grams that we dumped in there? Or
Chairman, we at the State Crime Lab, we have a validated method to quantitate or tell the purity of solid methamphetamine. We only use that in federal cases because that's the only place it matters for sentencing. Our state statute doesn't have the same sentencing guidelines that the federal government does. So the only time we use that is on solid meth in a federal case at the federal prosecutor's request. In terms of liquid methamphetamine, we do not have a validated method for that. We do not have a validated method to quantitate or tell the purity of every other controlled substance out there either.
okay, thank you for clarifying. Further, go ahead, Representative Oakley.
Thank you, Mr. Chairman. So I just wanted to go back to a point that Co-Chair Washit was talking about incentivizing distribution. Any sort of delivery or distribution is a different statute, holding much higher penalties. This is just the possession statutes. And it's, it's not going to be perfect for every little, again, how concentrated is it that you owned, or how much, of course, these are generalities and guidelines, and then we can use how much you had for sentencing. But, you have to come up with some categories and some rules, with possession. And the reality is this doesn't change that much of it. It's just changing the form. It's just a different way of looking at it, which makes more sense. Let me use this example. So marijuana right now, first of all, you have to pick like in plant form. Well, we know marijuana just is in so many different forms, right? So we're this is trying to fix that. And again, in that way, as far as this liquid stuff, it's liberalized it and greatly increased the amount. And then I guess finally, I'd just like to say, we have some good would-be defense attorneys on the panel, but the reality is sometimes you kind of get in the weeds with it, and that's fine. A defense attorney can make those, but we're talking about making the rules for reality on the ground. Like, people aren't mixing their liquid methamphetamine and drinking it. They're shooting it. And that's what we're trying to prohibit the conduct, make the rules clear. If they can, if they dump it in water, I guess we can see what happens. But I've never heard of that. I haven't seen that on the ground, and I don't think it's really important for us to figure out sort of these guidelines of what makes possession illegal.
Thank you for that, Representative. We'll look forward to debating this a little bit further after we get whatever testimony. But any other questions for the Attorney General's office? Any other questions? All of you, appreciate it. We will reserve the right to maybe call you up later, okay? Do we have anyone here from DCI? Division of Criminal Investigation. Oh, Waldock, excuse me. Thank you. How about the Department of Agriculture? Do we have anybody online or here? Oh, there we go. I missed you, Director. Thanks for being here. I didn't see you back there. Good morning. Yeah.
Turn your microphone.
Oh, it's not.
Oh, it was, yeah.
Got it. Sorry about that,
You're
Mr.
good.
Chairman.
Thank
Good
you.
morning, committee.
Good morning.
My name's Doug Miyamoto. I'm with the Wyoming Department of Agriculture. With me today, I have Slade Franklin. He's the manager of our Technical Services Division within the Department of Ag. And I also have Teresa Jarvis. She's your Wyoming State Chemist and also runs our Analytical Services Lab over in Laramie. And those are the two individuals that primarily run our hemp program. And so that's what I came to talk about today, and I'm happy to answer any questions about the way that we do our hemp program, and pleasure of yours, Mr. Chairman, of how you would like me to begin. Background of the hemp program, perhaps, or however you want to proceed is
You know what,
is great.
Director? We're going to take you up on that, but we're going to reserve that for just a little bit later.
Okay.
Right now, we're going to deal with the Controlled Substances Act bill, and then we'll get to you folks. We really look forward to learning from all of you. So
Understood.
thank you for being here. Anything on this particular bill for now that you have, or? Yeah.
Mr. Chairman, not on this portion, not on the controlled substances part of the
Okay,
the
good enough.
consideration today.
Thank you, Director. Really appreciate you being here. We'll reserve the opportunity to call you up a little bit later.
Understood.
Do we have anyone else who would like to testify for us on number 54, Controlled Substances Act? Good morning, Chairman. Good to see you.
Good morning, Mr.
Welcome
Chairman.
back.
Thank you. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And not to belabor the point of the 0.3 in liquid form versus the 3 grams in liquid form, but from my experience, it's been understood from law enforcement working the street that some of the most dangerous actions that we're taking in encountering people using liquid substance is in finding the loaded syringe in a car, in somebody's pocket. Very seldom is it capped. And it's always been my belief, I don't know what the intention of the legislature was when that was enacted, to differentiate between the 3 grams and the 0.3 grams of liquid. But it's always been my assumption that is because of the danger, the officer safety aspect of it, differentiating between 3 grams of solid crystalline form methamphetamine and 0.3 grams. We don't find it in a toilet bowl. We don't find it in a glass of water. We don't find it in gallons of carrier agents. We find it in a loaded syringe, and that's where it's about 0.3 grams in a loaded syringe to make the felony amount.
Questions for the sheriffs and chiefs of police? Really appreciate it. Thank you. Oh, go ahead, Representative Prego.
Sorry. Thank you, Mr. Chairman. Mr. Thompson, so just so we're clear, does the association support this bill draft or not?
I'm just explaining the difference. I think the logic in the difference between a crystalline and a liquid form. I think it makes sense to differentiate that from an officer safety standpoint, but I'm just hoping to explain it better.
Okay, follow up.
You bet.
So do you have an opinion on the particular bill draft before us?
I think the bill draft itself cleans up the language that makes it easier for an officer to understand the application of it. And whatever the committee decides on weights, I think is the committee's purview. But it helps, I think, the language in understanding and applying the law on the street.
Thank you.
Representative Oakley.
Thank you, Mr. Chairman. Quickly, but so you would appreciate that if we added the liquid methamphetamine back into or included it with the LSD as the 0.3 grams? Would that be fair to say?
I personally would support that. I would imagine that the association would.
Okay. Senator Case?
Mr. Chairman, I'm never going to get over my struggles on this, but why can't we deal with the crime of having the syringe with any quantity and call that a felony? I mean, that seems to be very important. It seems to be very dramatic. It seems to be in the criminal world. Uh, um,
So Senator, I can't answer that, but I bet somebody might.
Well, I was
be
asking you,
willing.
Mr. Chairman. No, I'm asking the gentleman.
I'm listening carefully.
But the idea would be a syringe is dangerous for everybody involved. It's something we don't want. Why don't we, and so if it has any quantity, make that the higher penalty. And then not worry so much about the translation from 3 grams to 3 ounces.
You know, I think, Senator, I understand where you're going. I think we can have that conversation as we work the bill a little bit later. And we may have some suggested amendments. So we'll tackle those in a few minutes. But in the meantime, Mr. Thompson, anything else on this bill?
No.
Any questions? Okay, thank you.
Thank you, Mr.
for
Chairman.
being here. Let's go to further public comment on LSO 54 Controlled Substances Act. Any further testimony? Clarissa, do we have anybody online who wants to testify on this bill?
Mr. Chairman, we do. We have Richard Jones online, and then if other folks could please raise their hand if they're interested in testifying. I believe most folks want to speak on the next
Okay,
two
let's
bill
bring
drafts.
Richard Jones on board then, please. Clarissa, do we have him on board?
Mr. Chairman, we do. He just needs to unmute his mic and turn on his
Okay,
video.
Mr. Jones, would you please unmute your microphone and turn on your video? We still can't hear you, Mr. Jones. Mr. Jones, you're not coming through at this point. Okay, I'm sorry we were unable to connect with Mr. Jones. Maybe we can get him back later in the morning, but Clarissa, do we have anyone else who's raised their hand on this bill?
Mr. Chairman, I don't see anyone else.
Okay, one more time. Any further testimony? Okay, I'm going to close public testimony on this bill. Committee, what's your pleasure on 54? If we have a motion, okay, let's get a motion in a second, and then we're going to have discussion. How about that? So I have a motion. Do I have a second on the bill? Okay, a second for Representative Oakley. Now, Representative Oakley, discussion.
Thank you, Mr. Chairman, and I do this with much trepidation, but it does strike me that, and I don't know, maybe it's too broad, but we've had some discussions about marijuana and perhaps lessening the penalties associated with that. While we're dealing with the law, it strikes me that it's a, and we've separated out marijuana, that it would be an opportunity for us to lessen the penalties for possession of marijuana while we're putting these in here. That's something we haven't discussed yet, but I'm just, I guess, throwing that out there for the committee's thoughts.
Does anyone else have any thoughts on that notion? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I wouldn't be in favor of reducing penalties. However, I do have concern on page 5 when we talk about possession of an amount less than 3 ounces. One thing that we're not taking into consideration is the high potency of today's THC. And, you know, back in the 80s, that would have been, you know, the potency would have been for this amount like almost 1,000 joints versus 100 of today's high potency THC. And so I think that this is pretty lenient compared to other states throughout the nation.
Representative, did you say lenient? Okay.
Mr. Chairman,
Senator Case.
would you mind if we had Representative Oakley make her point again about how marijuana fits into this and how it's less now?
Absolutely. Representative Oakley, would you be willing to cover that again for us?
Thank you, Mr. Chairman, and I think I understand the question. Tell me if I'm not answering.
I'm not sure I understand what you said. so
Well,
thank you.
okay.
Yeah.
So what I'm saying here is that there has been some discussion, obviously, before this committee, anywhere from what's called decrim, and there's legalization of marijuana, which did not pass and has not passed Wyoming. But here we are dealing with dealing with the possession statutes, and we've taken out marijuana as a separate, so page 6, starting with line 4, now we've kind of separated, and that's what this allows us to do, this changing the form. We've got marijuana as a, kind of a separate group. This would give us the opportunity, so then if you look at the punishment sections, so page 6, lines 4 through 9, we outline what it is specifically to have a felony amount of marijuana. Since we're dealing with this statute, it would give us, we could look at lowering, because this is what's currently the punishment in statute. They didn't change that.
Okay.
I'm saying since we're looking at these possession statutes, this would give us an opportunity to look at, and marijuana is broken out in its own section, that we could lower the penalties for possession of marijuana if we wanted to. Obviously, policy discussion.
And Mr. Chairman,
Go ahead, Senator.
is that something that we should do now? Or are you saying that the bill title would permit us to do that after it was introduced in the legislature? Because sometimes that's tricky, because you can do more and you can do anything in the committee, and you need to be within the title very carefully when you get in session. So I'm trying to follow you on that, because I'm interested in going down that road, but I'm not sure the committee is.
Before I go to Representative Oakley, Mr. Fuller, did you understand that question from Senator Case? And I would have the same one. Are we getting off the beaten path here in terms of the title of the bill, or?
Mr. Chairman, at this point, I mean, the bill has not been introduced. I think anything's fair game, and certainly if an amendment weren't within the title, that would be a conforming amendment that could be made now before a vote to sponsor the bill takes place.
Okay, thank you for that.
And Mr. Chairman,
So real quickly, Senator Case, and then I'll come back to Representative.
and then if we can go back to Mr. Fuller. So, Mr. Fuller, with this title, if this bill were introduced without any amendments, with this title in the session, do you think we could deal with the level of penalties for marijuana? I think that's the question, because I suspect people won't, they may draw the line in the sand now, but we have two different houses and things will go in different directions. I agree that we should broaden the title so we can work, but my colleagues on this committee may not.
That was actually my question, asked a little bit better by the senator.
So, Mr. Chairman, Senator Case, page 1, lines 6 and 7, the title currently reads specifying penalties based on the amount of controlled substances. So there's a pretty broad reference to, specifying penalties for those amounts.
Senator Case, that sounds like we're covered, but. go
It
ahead.
does, but it doesn't say amending the penalties.
And,
And it's a kind of a recodification in some ways. So I get you. I'll trust you.
And Mr. Chairman, Senator Case, a fair point, certainly one that the committee could consider.
So we could ponder specifying versus amending, perhaps. But anyway, go ahead, Representative Oakley.
Thank you, Mr. Chair. I don't have much more. I figured Senator Case might jump on this, and I did this with trepidation because I am interested in cleaning up these possession statutes, and I recognized when I brought it up, this could send this in a couple different directions, but I just thought it would be it could be an appropriate time for us to discuss that as well, since we're dealing with it. So that's all I've got to say.
I think the caution that the representative is throwing out, committee, is just the fact that this bill is designed to clean up some statutes. And if we deal with too many other things, we could jeopardize, the future of the bill. So keep that in the back of your mind. But I think it's spot on. We do have an opportunity to look at that, and we can do that through the amendment process this morning. I'm inclined to work the bill. So be thinking if it says what we need it to say. On page 1. Senator Case.
I propose we amend the title to make it more flexible to alter penalties.
Senator, what did you have in mind specifically?
Hold on here. How about line 6, specifying and amending penalties? Or just amending?
Instead of
Either way.
specifying, would it suffice to just say amending?
I'm okay with that.
Okay, second by Representative Crago. Discussion.
No, Craig's trying to
Oh,
get your attention.
let me back up and ask if there's a second to the motion to the amendment. Okay, seconded by Senator Schuler. And now we have discussion. Representative Crago.
Sorry, Mr. Chairman. So just my question, I guess, on the proposed amendment, because I actually like specifying and amending. And the reason being is I'm not sure we aren't creating a few new I think we might be creating a new category or two. So we wouldn't be amending, we'd actually be specifying for some of those new
Mr. Chairman, I
classifications.
withdraw, and I will propose the alternative, specifying and amendment, and amending.
Is that a friendly amendment, and one that Senator Schuler has seconded that one? So does everyone understand the proposed amendment? Mr. Co-Chairman.
Thank you, Mr. Chairman. My concern here is if we pass this amendment and then we don't amend any penalties, have we now created a problem with the title that says that we're specifying and amending? So this amendment presupposes an amendment to penalties will occur elsewhere in the statute. And should we not go down that path, now we have a title that we're going to have to go back and re-amend.
Mr. Fuller, can you?
Mr. Chairman, Chairman Washut, I'm not sure that there would be a concern, about a bill title being too broad rather than being too narrow, for example. Mr. Chairman, the other thought too is, there was discussion about, even though the penalties themselves may not have changed, that the effect of that change, the liquid methamphetamine that was discussed, the psilocybin mushrooms, effectively changes, are being changed.
Senator Case.
I'd make the same point. We're changing quantities under penalties, so we're amending penalties. And talking about forms and stuff like that, so it's even better to have amending in there to preserve the existing bill.
I think we're good. Committee, I think we're fine. The language, is there any other discussion or questions on the amendment? All those in favor of the amendment, say aye. Aye. Any opposed, no? No. That amendment passes. Anything further on page 1? Is there anything on page 2? Page 3? Anything on page 3? Page 4? Representative Oakley.
Thank you, Mr. Chairman. I would move to add the liquid methamphetamine back into this section that is 0.3 of a gram. It's as we heard, it's definitely one of them that we see on the street that's being shot up, which is very dangerous, and I think should remain as 0.3 of a gram for a felony possession.
And so Representative Oakley, can you help to identify where we would move that in, just so the committee understands?
It would be at the end of page 4, line 8, or, and then I would defer to, the exact language from how it's used in the statute before Mr. Fuller, but, or liquid methamphetamine.
Yep, or methamphetamine in liquid form was what I was thinking, Mr. Chairman.
So after the parenthesis on line 8, Representative Oakley?
Yes, you're up. Sorry. Yes, Mr. Chair. Or methamphetamine in liquid form.
And then, Mr. Chairman, I assume LSO could make any necessary conforming amendments.
Okay, thank you for that, Mr. Fuller. We always appreciate that very much. Does everyone understand the proposed amendment? Do I have a second on the amendment? Seconded by Representative Demick.
Discussion.
Senator Case.
Thank you, Mr. Chairman. So I'm trying to understand one thing too. So do people inject LSD? I mean, I think you're talking about injectable forms. I'm not aware, I'm not an expert, but I don't think it's commonly injected. And I'd like to go back and say that if you want to get these injectables, you could treat them differently and make any amount of severe crime. But I'm not sure that the delivery system for LSD is the same as it is for this liquid methamphetamine. But please correct me if I'm wrong, because I don't know anything about this really.
Further discussions? Representative Oakley.
Thank you, Mr. Chairman. Senator Case, I think your point actually makes my point in that it's about the possession of it. So LSD might be consumed different than liquid methamphetamine, but it's the dangerousness of the liquid is that these high concentrates that all of these different controlled substances act differently and are consumed differently. So we're finding the way that the possession of them, because you're going to use them, is illegal. So LSD is delivered different than methamphetamine, but the high concentrate in these is what makes it dangerous, so that such a low level of possession makes it a felony crime. So it's not about the container or, that's the point.
Senator Case.
My good friend from Fremont County used the word concentrate. The high concentrate is dangerous. High concentrate is high concentrate. This has nothing to do with concentration. It's all about the weight of the final product, which is a liquid. It could be diluted.
Further discussion on the proposed amendment? Representative Chetty, good morning.
I am completely out of my depth in this whole field, but should there be a similar amendment then in section 9 on page 5 to add the liquid form of methamphetamine on line 3, just to be consistent?
Mr. Fuller, can you take a look at that? Is that that's a good question. I don't know if we move meth in liquid form onto line 3, page 5, in addition to what we're doing on page 4, just for conforming. Does that make sense?
So Mr. Chairman, if you add meth in liquid form here, that would cover less than 0.3 of a gram. Then on page 5, where you have LSD and the felony amount, 0.3 of a gram or more, I assume the committee's intent would be, that liquid meth would be included there as well. But certainly, happy to take the committee's direction, the clear direction on that.
So Representative, I think that's probably conforming, but that's a very good catch. Thank you for that. I think committee, does everyone understand the conforming amendment, which goes to line 3 on page 5? Does everybody understand that? Okay. So meth in liquid form will be referenced in both spots. Any further discussion? Go ahead, Representative Craigo.
I'm confused, Mr. Chairman. I mean, as I read through the statute or the proposed statute, the bill, I mean, so on page 3, all of that is talking about really, I mean, it gets into methamphetamine, I think, above that, above the sections beginning on line 22. So are we going to have a lot of confusion within the bill draft itself based on, I mean, we're getting back to the same problem we have in our current statute, which is the form issue. Are we gumming it up, I guess is my question. And I get what Representative Oakley's trying to get at. I support that. I just am not sure where we put that and whether we just create a, whole new statute based on liquid versus not liquid. I don't know the answer to that, but if you start reading down here, I think we're gonna run into some clarification problems.
Mr. Fuller,
Yeah.
go ahead.
So Mr. Chairman, I think another conforming amendment, if, as the amendment stands right now on page 3, line 22, you would have to say except as provided in paragraph 8, to make clear that you're separating that out from that reference to methamphetamine on line 23.
So help us, Mr. Fuller, with a little more specificity,
Yep.
if you would, on page
So-
5, line 23, committee.
So Mr. Chairman, I'll just go through what I understand the amendment would read based on the mover. So page 3, line 22, before any, it would be except as provided in paragraph 8 of this subsection. Then on page 4, line 8, Mr. Chairman, maybe for clarity, after possession, insert methamphetamine in liquid form or. And then page 5, line 3, after possession, insert methamphetamine in liquid form or.
Okay, one more time, Brian, my apologies, but can you take me to the bottom of page 3 again? I want to make sure the committee's up to speed on what we're doing.
So.
Line 22.
Yep, so Mr. Chairman, this would strictly be a conforming amendment, and it would just be, so after the 7, you would start the sentence now, except as provided in paragraph, and I think you would say paragraphs 8 and 9 of this subsection.
Okay, committee, does everyone understand where we are with the amendment? What we've done on page 3 and on page 5 is simply conforming. Concerns as we go forward with this bill, we may discover that we want to tweak language, but this simply brings in meth in liquid form. Is there any further discussion on this amendment? All in favor of the amendment, say aye.
Aye.
Any opposed? No. That amendment has passed. We're back on the bill. Page 5 is the next page for our consideration. Anything on page 5? Anything on page 6? Anything on page 6, line 4? Anything on page 7? Senator Case.
Mr. Chairman, 6 and 7 are marijuana, and it'll be fun to mess with that, I think, but I think I'll wait till a better form.
Just to remind everybody, the committee knows this, but just so everyone knows this, bills have a long ways to go from the committee and all the way through next March. So anything further, committee, on this bill? Representative Craigo.
Thank you, Mr. Chairman. I believe when we were hearing testimony, Ms. Barrett also referenced heroin in liquid form. If we were going to do the meth, we should probably add that back in on page on pages 3, 4, and 5, possibly. So I'd make that motion.
So do I have a second by Representative Oakley? So Representative Craigo, that would go right back into paragraph 8 where we've been, and we would simply include heroin.
Yes, Mr. Chairman.
That could be a conforming amendment committee, in my opinion. Does everybody understand what we're doing? Is there discussion? Go ahead, Representative Chesty.
I don't see that as a conforming amendment. That's adding something substantive, I think. So I would prefer to have a vote on that. I'm in favor of it, but I think it would be clearer if we actually had a vote on it.
Yeah, and Representative, my apologies. I referenced that a little bit wrong. I think we're, if we want to get more specific though, let's do that. And so I'm looking at the sponsor of the amendment. We would bring that in, for example, on line 8, page 4, possession of methamphetamine in liquid form or LSD, we would have to bring in heroin maybe to begin that. Possession of heroin, comma, methamphetamine, comma, or LSD. Is that your intention, Representative Craigo?
Mr. Chairman, I believe so, but I think it's heroin maybe in liquid form. I guess we could ask Ms. Barrett, but I think that was the question that Representative Oakley had posed to Ms. Barrett. Is there anything else we're missing in liquid form if we bring this set of amendments?
Ms. Barrett, would you be willing to come up real quickly? We're trying real hard not to put a hole in the boat.
Chairman, could you repeat the question?
Sorry to put you on the spot, but what we've done on page 4, as you may have been listening in, we have added methamphetamine in liquid form back into that paragraph. The amendment on the floor right now is to add heroin. And the question by the sponsor of the amendment, did you say heroin in liquid form?
Yes.
And can you give any guidance on paragraph 8 on page 4?
Chairman.
Addition of those two substances. Any thoughts?
Chairman, Representative Craigo, I did say heroin in liquid form. We do see it in solid form as well, and currently in statute, solid form would be 3 grams. So, so I did say heroin in liquid form. Do you have any on the wording?
Chairman, I believe just as Mr. Fuller added liquid methamphetamine in those various areas as we went through the bill, the appropriate language would be to add liquid heroin in those different areas that Mr. Fuller already addressed.
Representative.
Thank you, Mr. Chairman. So not to beat a dead horse, are we missing any other liquids that we're seeing significantly?
Yes,
Ms.
Chairman,
Barrett.
Representative Oakley. While I was sitting back there, the thought came to me that we sometimes, not routinely, but sometimes see fentanyl in liquid form.
Stand back, committee. We're not sure how big this paragraph's going to get. Representative Craigo.
Thank you, Mr. Chairman. I guess I'd like to, maybe we could do a friendly amendment and add fentanyl to my previous motion.
And that is okay with the second. So committee, now, does everyone understand that we are considering heroin and fentanyl? Go ahead, Representative.
And just to clarify, in liquid form.
Both in liquid form. Representative Chestik, are you comfortable with Mr. Fuller helping us to import that language properly? Okay. Committee, any further discussion on this? All in favor of the amendment, please say aye. Aye. Any opposed, no. That amendment passes. We're back on the bill. I think we've covered all the way through. Any further discussion? Okay. Clarissa, well, let's, are we good? We're going to move to the next two in just a moment. So Clarissa, would you please take the roll on 54?
Senator Case? Senator Cooper?
Aye.
Senator Furphy? Senator Schuler? Representative Chestek? Representative Crago? Representative Haroldson? Representative Jennings? Excused.
Is he excused?
Representative Nemec? Representative Oakley?
Aye.
Representative Provenza?
Excused.
Representative Rodriguez-Williams? Chairman Landon?
Aye.
Co-Chairman Washut?
Aye. Aye.
Okay. That bill has passed the committee, and we'll move on to the session. Committee, let's take up the next two. And Mr. Fuller, can you walk us through LSO 55, Delta 8 controlled substances,
Yep.
please?
And Mr. Chairman, perhaps in the interest of economy, I would walk through both 55 and 129 with your permission.
I think that's a good approach. Thank you, Mr. Fuller. Please,
Yep.
we're taking up now 55 and 129 explanation. Go ahead, Mr.
Yep,
Fuller.
so Mr. Chairman, I'll start with 24 LSO 55, working draft .4, 13-02 in the online materials. This is a bill draft that the committee requested in April after discussion from DCI. And all this act does is clarifies that Delta 8 and its isomers are included in Schedule 1 of the Controlled Substance Act. Page 2, lines 18 and 19 inserts Delta 8 into Schedule 1, and you'll see that's part of the tetrahydrocannabinols paragraph. Delta 6 is already listed there. This would just add Delta 8. And Mr. Chairman, I'm happy to stand for questions on this draft.
Questions on Bill Draft 55, committee? Does everybody understand what we're doing on this bill? Okay, thank you, Mr. Fuller. Please proceed.
Yep, so Mr. Chairman, 24 LS 129, working draft .4. This was a draft that the co-chairman directed LSO to draft. It prohibits hemp that has any detectable amount of natural or synthetic THC, and it prohibits hemp intended for human consumption. So starting on page 2, lines 12 to 14, this is in the hemp statute, so Title 11, Chapter 51 of the Wyoming statutes. And in the definition of hemp or hemp product, on lines 12 through 14, it strikes reference to a THC concentration of not more than 0.3% and inserts the words no detectable. So it would be a product with no detectable THC concentration. Page 2, lines 18 to 20 makes the same change in the definition of process, converting hemp into another product that contains no detectable THC. Page 3, beginning on line 2, amends the definition of THC in the hemp statutes. So conforming language on page 3, line 2, and then conforming language on line 4. Page 3, line 8 adds to the definition of THC any synthetic THC, including any synthetic substance listed in 35.7.10.14 D21. That's the paragraph that's in 55. So the previous bill, that's what this is referencing, and then also a specific reference to Delta 8. And then page 3, line 13 adds to the definition of THC any other THC isomer that mimics the intoxicating effects of a substance specified in A and B. Page 3, line 18 is a definition of edible, so any product primarily intended for human consumption. Page 4, line 4 is a conforming amendment. This subsection provides that the possession, purchase, sale, and transportation and use of hemp and hemp products is allowable except as provided, and we're adding subsection C. And so page 4, line 7 provides that no person shall produce, process, possess, purchase, sell, transport, or use edible hemp or any edible hemp product. The The staff comment just notes that the committee may wish to consider what penalty, and I'll discuss that here in a moment. On page 4, page 5, lines 1 and 2, and 14 and 16 are conforming amendments to reference no detectable amount of THC. The staff comment on page 6 provides the current language for penalties associated with violation of the hemp production statute. Currently, any person who intentionally violates the chapter it'd be a misdemeanor up to 6 months and a fine up to $750. And then subsection D is concerning licensure, which may not fit with the particular provisions here. So I just note that for the committee's consideration. Page 6, beginning with line 31, is an amendment to the Controlled Substance Act. It changes the definition of hemp to reference no detectable THC concentration, and then it inserts the definition of THC. Page 7, line 8 is an applicability section. Just notes that nothing in the act is construed to preclude any action that's legal before the effective date of this act. Section 3 is rulemaking for the Department of Agriculture, and then a split effective date. The rulemaking would be immediate. The remainder of the bill would be July 1, 2024. With that, Mr. Chairman, I stand for questions.
Questions of Mr. Fuller? Go ahead, Representative.
Thank you, Mr. Chairman. Mr. Fuller, so looking at LSO 24 LSO-0129 on page 4, line 7, no person shall produce, process, possess, or purchase, sell, transport, or use edible hemp or any edible hemp product. That would encompass all CBD products, would it not?
Mr. Fuller?
Yeah, Mr. Chairman, any product that has any detectable amount of THC that's edible would be prohibited.
Mr. Chairman, follow up?
Go ahead,
Mr. Fuller, that doesn't say THC, that just says is an edible hemp product.
Yep.
So it doesn't even have a THC backing to it, just a hemp backing.
So
Go ahead, Mr. Fuller.
Mr. Chairman, Representative Haroldson, this is where the definitions would come in. So edible is now defined. That's on page 3, line 18. And then hemp or hemp product is defined on page 2, beginning on line 8. And that is where the THC reference would come in, is in the definition of hemp or hemp product.
Senator Case.
Mr. Chairman, and this may not be an appropriate question for Mr. Fuller, but the question is detectability. That means one molecule, right? I mean, find one molecule. So I suspect that there are molecules of THC in this room right now. There are molecules of THC on people's clothing that didn't partake of marijuana. I mean, is that what we're really talking about? There's probably a molecule of THC in the air here.
So if Mr. Fuller can't answer that, I bet we've got someone who can at least.
Well, and then if Mr. Fuller can't answer that, I defer and took testimony from others.
Yep.
Yeah,
So,
thank you, Senator. Go ahead, Mr.
Mr. Chairman, the only Senator Case, what I would say with detectable, I think the intent there is, something that would show up on a test.
Mr. Chairman, I think that's going to go to what we're going to talk about, if you don't mind. Detectability is getting better and better and better and better, the theoretics of detectability. So this will be interesting.
No question, Senator, that'll be part of the debate today. So let's be sure and keep Ms. Barrett in her chair and don't let her leave. We've got a question on that front. But any other questions of Mr. Fuller and the drafting of this bill? Okay, let's go to the Attorney General's office, DCI. Again, welcome. Take it away. We have 2 bills in front of us, and glad to take them both. Let's start with maybe 55, the Delta 8 Controlled Substance Bill. Let's see if we can't get arms around that one, okay? Thank you.
Thank you, Mr. Chairman, committee. Thank you again for addressing this Delta 8 issue. DCI doesn't necessarily have an issue with the amendment, but we're not certain it does what this committee believes it to do. Delta 8 naturally occurs in small quantities in hemp, but it can be synthetically modified, converted to have the psychoactive effect that THC would have. The problem is the crime lab can't test the difference. They can't tell the difference. They don't know if it's the Delta 8 that's naturally occurring in hemp or the synthetically modified that's in THC. And while most Delta 8 we see is likely through the synthetic process, the crime lab can't say that in court. They can't testify to that. So we run into an issue of whether a substance is hemp or whether it's THC. And we're not sure the amendment rectifies the problem because of the naturally occurring Delta 8 in legal hemp. So with that, Ms. Barrett might be able to explain that a little further for you. And I'll leave Senator Case's question for a minute when we address that bill.
So, thank you, Kelsey, appreciate that. I would ask along the way, maybe if you had an idea for language that might work, but let's go to Ms. Barrett.
Thank you, Chairman. So I believe I testified last time that Delta 8 THC occurs both naturally, it occurs naturally in very low levels in hemp and in any cannabis plant. I did some digging because you guys asked me last time, and I saw less than 0.1%. I saw negligible amounts, that type of wording, so not significant amounts in naturally occurring marijuana or hemp. So I hope that that answers your question. Like Ms. Singleton indicated, I don't believe the current amendment fixes the issue that we're having because it's with the word synthetic and naturally occurring. That's the current issue. I looked into some other states, and the way they deal with this is with terms like isomerization. They prevent chemical modification of hemp cannabinoids into other types of cannabinoids.
So, Ms. Barrett, I just learned a new word. Can you say that word again for me, please?
Isomerization. So it means taking CBD, for example, applying a chemical process to make an isomer of CBD, which would be Delta 8 THC. Other states say chemical modification. It's a little easier. And so that would also work.
Thank you. Go ahead, Representative Oakley.
Thank you, Mr. Chairman. Ms. Barrett, so I too remember that discussion, and I thought that's what we were gonna do, is kind of take out synthetically created so that it would be either synthetic or natural. And then along with that, if we did that, what you're saying, and then we left the hemp at the 0.3, it shouldn't affect that. Is that,
Correct.
would that, like, that wouldn't be something detectable in hemp? Because I think we've gone down a path that's scaring people, and I understand that, and I don't think that was the intent. So you think we can get there with the Delta 8 by including Delta 8, taking out any sort of categorization of whether it's natural or synthetic? And we can get there with the Delta 8, leave hemp alone at 0.3, that's it, simple fix.
I believe so.
Thank you, Ms. Barrett. Thank you. Go ahead.
I have one more point. So currently in our statute, and I'm looking at 55, page 2, line 18, actually line 17. This is really tricky, and so
Mr. Chairman, could she pull the microphone a little closer?
My apologies.
Yep,
Yes,
no.
is that better? Okay.
Thank you, Ms. Barrett.
So page 2, line 17, Delta 6 THC, and then you've added Delta 8 THC. Those are the exact same compound, so it's not necessary. Now, if you would want to change Delta 6 THC to Delta 8 THC for clarification, that would make sense to me. But as it stands, they're the same chemical. It's all about, there's two different ways to name chemicals. And so one uses one way, another uses another way. It's kind of like we spell color C-O-L-O-R. In England, they might spell it C-O-L-O-U-R. So different naming convention, but it means the same thing to me. So I think it's duplicate to have it in both, but I understand it would clarify and clear up for the public or whoever, anybody reading this, that we are prohibiting Delta 8 if you wanted to change Delta 6 THC to Delta 8 THC.
Okay, thanks for that suggestion. We'll take that up as we work the bill, Ms. Barrett. Thank you. Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So just so we're clear, Delta 6 is illegal under present statute.
Yes,
And you're saying that it's exactly the same as Delta 8.
yes.
So Delta 8 is already illegal under present statute, correct?
Delta 8 is already listed in Schedule 1. The problem is that with that hemp section of our statute, it exempts naturally occurring cannabinoids. And because it naturally occurs in very low levels, the argument is made then that the hemp is derived, or the Delta 8 is derived from hemp. Well, they're applying a chemical process to do that, which would be synthetic. But we can't prove that. There's no test to prove for that.
Thank you for that, Mr. Co-Chairman. Representative Chetsi.
Thank you, Mr. Chairman. Isn't the fact that it's more than negligible proof that it's synthetic? If it naturally occurs in a very small quantity and you find something that's 10 times more than that, doesn't that itself prove that it's synthetic?
So, Ms. Barrett, I think I heard you testify that you've seen it as high as 20% maybe, but go ahead.
Chairman, Representative, I think that is a very practical answer. My answer would be yes, practically. Scientifically, what I have to do, and the chemists that work for me have to do, is apply a scientific process to prove that in court. And that's where we're not making the jump, is there isn't a scientific test we can do right now to prove that. So practically, yes, but I can't testify to that when I go to court.
Representative Oakley.
Thank you, Mr. Chairman. So again, all we need to do for a fix is to take out a reference to how it's created, because the percentage would speak for itself. And that's the problem. When it says you have to prove that it's 0.3 or less, or that it's synthetically created, we can't do that. If we just say it's illegal to have this in over this concentration, then the statute is clear. And it's kind of where I thought we were getting, kind of gotten a little off track here. I mean, I think we literally just take out the words referring to how it came about. And we say, if it's over this, the statute's there, except it refers to synthetically created. We remove that and we get where we need, and we put all of this to bed, as far as my understanding.
Representative Oakley, I believe I follow, and I think what you just said is correct. We'll have to work that carefully. I think hopefully the public and everyone here today is beginning to get an understanding of the hole that we're trying to fill in the statutes. We just need to try to do it correctly. So further question, Representative Harrelson.
Thank you, Mr. Chairman. And so just to bring the whole conversation, because obviously we have online, we have the audience here, and everyone's concerned when they look at that and say, we went against an agricultural industry with this bill type of deal. And what we're talking about is we're talking about high school students that are going to hospitals and ambulances. That's why we're here today. We're not here to try take people's CBD away from them. We're not here to try take and shut down the hemp production in the state. But what we are saying is, hey, we've got a problem, because welcome to humanity. We look for a loophole and we'll exploit it. That's the reality of mankind. And now what we've created instead is that, probably through a mistake, that we're attacking an industry that we were never intending to attack. What we're trying to say is we want to make this product illegal, just so that we can protect and have an opportunity to protect not only the people of the state, but the students of the state. And I wanted to just say that. Is that a good statement that I'm making there? Would you guys agree?
So it's a good thing he phrased it as a question there at the end. Representative Harrelson is saying, don't you think?
I would say that's in the committee's discretion, Chairman.
As long as, committee, as long as we can get to the the synthetic production piece, and I think that Representative Oakley maybe hit on something, but as long as we're comfortable that that would do what we need it to, I'd be probably a little more comfortable with some specificity on, this means you cannot artificially increase the amount of X, Y, or Z. Go ahead, Mr. Co-Chairman.
Mr. Co-Chairman, with all this discussion, I think it's important that we take this bill draft up again in November, that whatever we do today in terms of trying to massage this language to fill that hole or loophole or whatever we want to describe it, that we need to take another look at this in November when we have all the language kind of worked out. So I would urge the committee not to try and pass something today and call it done.
I agree. So the co-chairmen have made a decision on that, folks. We're going to work this bill all the way through. We're going to work 129. And then just so the public knows, we will take this up again in November. We're not intending to knee jerk anything. But go ahead. Representative Oakley?
Thank you, Mr. Chairman. So I guess, I don't know if it's permission or I guess just asking Mr. Fuller if we think we can take this and remove synthetic and remove the language about how it's created and just go with the percentage. Is that something we can do via this bill draft?
Mr. Fuller?
So, Mr. Chairman, Representative Oakley, I assume you're talking about 129. So
5055, page 2.
So, Mr. Chairman, in terms of percentages, I mean, this draft just lists what substances, and I believe it was a testimony of Ms. Barrett that Delta 6 is Delta 8. I'm certainly no chemist or scientist by any means, so I'm not sure this would, I think the question for the committee is the necessity of this bill as it's drafted. And maybe I'm not understanding, Representative Oakley, I'm not understanding your question.
So your thought is 129 would certainly cover, and thereby we would not need 55. Is that kind of where you're headed, Mr. Fuller?
Mr. Chairman.
We've just been working 55, so go ahead.
Yep, Mr. Chairman, I don't want to, put words in the committee's mouth by any means. When I heard, Representative Oakley, the reference to percentage, I think if you say, a THC concentration of not more than 0.3%, THC could be, that definition could still be expanded to include Delta 8. So anything under 0.3% of Delta 9, Delta 8 is hemp. Anything above is not hemp, and it's a controlled substance.
Representative Oakley?
Thank you, Mr. Chairman. So yes, I think my understanding, so I think 129 goes too far, gets into the, which of course we've talked about. I think we want to leave the 0.3 alone. And so that's what I see 129 is dealing, kind of switching that, which, so I'm looking more at the definition, like in 55, where we start defining, when we define it, we do not include synthetic. And so, and again, maybe it's in the wrong place is what we have to figure out. But on 55, page 2, line 11, when we're defining these things and it says synthetic equivalent, that we want to get rid of trying to define THC or any cannabinoids by their creation. So it would be either synthetic or naturally occurring, which then I think we could either do that or just take that out and stop referring to how it is created. Just saying, this is what it is. It's Delta 6, it's Delta 8, and completely remove this reference to synthetic.
And Mr. Chairman, let's keep down here.
Senator Case.
Yeah, and tagging on that, I think if we go down this route, Representative Oakley has a pretty good idea, and then we wouldn't actually need the hemp bill at all. And that would be what we want to get to. We would want to make the Delta 8 controlled substance bill all-encompassing for the forms of THC, and irregardless of how it comes about, but it'd be in a concentration that matters. And then we would not bring down the roof on the hemp industry and the CBD oil industry and everything. We just set that bill aside. We could even table it today, and we could even do it and set the stage so that the poor public doesn't have to ream us for the next 4 hours.
Well, and sometimes we get what we deserve, Senator, but no, I think the issue, and appreciate the committee's work on this, the idea is to get rid of the capability of somebody to synthetically modify this product. And so I think that's where Representative Oakley is going. Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. I guess I want to hear from the chemists again. Is it the THC that we're concerned about in the Delta 8, or is there another cannabinoid that's at issue here?
There are over 100 cannabinoids in hemp and marijuana. And so
Don't tell us that.
I know, I know, sir. And so what we see currently is a lot of Delta 8 THC. We're starting to see some others. However, I think we'd be covered with what is currently written in the statute if we were able to eliminate the synthetic component, the reference to synthetic.
That's what she's trying.
Okay, so thank you, Ms. Barrett. That helps a lot. So, Mr. Friller, are you understanding where we think we might want to go with this? That's what I was afraid of.
Yeah,
Perhaps a healthy disagreement, but talk
so,
to me about that.
So, Mr. Chairman, yeah, I think that I'm having a disconnect, certainly. The language in 24 LSO 55, this is the Controlled Substance Act. These are the substances listed in Schedule 1 of the Controlled Substance Act. So paragraph 21, lines 11 and 12 talk about the synthetic equivalents of substances contained in the cannabis plant. And, you know, my understanding, Mr. Chairman, if you eliminate those words, you know, if you were to say repeal this paragraph, and maybe that's not the intent, or strike the word synthetic equivalents, you know, I think the question would be, are those now not Schedule 1 substances? And I just want, you know, I would appreciate, you know, clear direction for what, you know, where the committee would like this to go.
So, Mr. Fuller, I'm going to try to take a stab at this. I think what began this conversation, I believe Ms. Barrett pointed out that it's really, what we're trying to get at is the artificial additive, so to speak, to this product. And that's what the committee, I think, is trying to get rid of. So if we get rid of synthetic reference altogether and just say that we're fine with the hemp plant at 0.3 or less, that's kind of where we're trying to get to, Mr. Fuller, but we're not getting there, and I get it. So we need to work this a little bit further. Let's go with Mr. Co-Chairman and then Senator Schuler.
Thank you, Mr. Co-Chairman. So my concern is that are there
folks, let's listen to each other on the committee first. Thanks.
So-
Go ahead, Mr. Co-Chairman.
Are there other synthetics that might be captured in this language that we don't want to eliminate from statute? So I don't want to throw something else out, you know, the bath salts, some of these other things that we dealt with back in the day. I don't want to throw those away in order to try and get at the Delta 8 issue. So I'm thinking maybe we need synthetic or a product with a concentration over a certain level or something, as opposed to eliminating the word synthetic. Is that at all conceivable from a scientific?
I think,
Ms.
I
Barrett?
think, Chairman, I believe so. Um,
I'll let you ponder that for a minute. Senator Schuler, and then we'll go to Representative Craigo.
Thank you, Mr. Chairman. So, yeah, that was my question in essence, is most of these products on the market that we see in Wyoming, like your CBD products, aren't those synthetically produced? I mean, or are they not? Are they naturally, and they don't have any synthetics? I mean, that's my biggest concern, because I've heard from many of the old timers in my neck of the woods that use these products with CBD, and they don't want to go back to opiates and ibuprofen and that sort of thing. So that's my concern.
Ms. Barrett?
Chairman, so other states have dealt with this through using the terms chemical modification. So you cannot apply a chemical process in making CBD products. And that's how they eliminate Delta 8. So they don't specifically list it in their controlled substance portion of the statute. They do deal with it in their hemp regulation section by prohibiting chemical modification of any cannabinoid.
Let's go to Representative Craigo first, and then Representative Oakley.
Thank you, Mr. Chairman. So I guess this might be a question for Mr. Fuller, actually. If we take the word synthetic out, I mean, that seems to be a limiting term as it's used on page 2, line 11, right? So if we take that out, now we're saying, I mean, we could replace it with the word any. In theory, that's what we're doing. If we take out the word synthetic, we're replacing it with the word any. If we want, we can actually stick the word any in that particular position. In the statute, I mean, are we then saying, and then this might go back to Ms. Barrett as well, are we saying then it's any equivalent, whether it comes naturally or synthetically, of those particular, isomers within the plant? And so I think that's what Representative Oakley's trying to get at. I guess my question for Mr. Fuller is, from a drafting standpoint, do we get there? And then to Ms. Barrett secondarily, does that also get us to where they need us to get to at the lab?
Mr. Fuller, do you want to jump in real quickly on that?
I can try to. Mr. Chairman, Representative Craigo, if you change that to just any substance contained in the plant, there are more words here than just that. I mean, it's synthetic equivalents of the substances in the plant. So I think it would take some more work. Mr. Chairman, the other option too would be a draft along the lines of a separate draft along the lines of what Ms. Barrett has described.
Prohibiting chemical modification.
Correct, Mr. Chairman. And Mr. Chairman, that, just to clarify, that would go in the hemp statutes, I think.
Follow-ups, Representative Craigo, and then Representative Oakley.
Thank you, Mr. Chairman. So my follow-up I don't think we would want to remove the word equivalence. I think we would say any equivalence or any equivalent of the substances. And then that would include also synthetic and naturally occurring in a different type of plant, i.e. hemp. Because that's what we're really talking about, is the equivalent that's found in hemp and then is synthetically modified later to create the Delta 8, right? I mean, that's the problem we're trying to get at. So again, my question is if we took out the word synthetic and used the word any equivalent of a substance found in the plant, does that get, I don't know. I mean, I'm being honest when I ask the question, I'm not sure if that gets us. I think that's the idea, but I don't know if that solves the problem either. So just throwing that back to Mr. Fuller.
Let's go to Representative Oakley and then to the co-chairman.
Thank you, Mr. Chairman. So we keep going back to the chemical modification, but again, I don't know whether you call it synthetic or chemical modification. The whole point is we can't test for that. That's literally everything we're trying to do here is not limited to synthetic or chemical modification. If removal is too confusing, then all we have to do is do the synthetic or naturally occurring. The point is that the testing cannot determine how it was made. So we cannot limit it to synthetic or chemical modification. We're saying, and that's exactly what Representative Craigo was trying to get to, any might work. But if the limiting of how it was created is confusing us, then let's increase how it was created, which is any way, or synthetically or naturally occurring. but we're just trying to get at not cutting that in half and saying only synthetic, because they cannot determine the difference between naturally occurring and synthetic. So maybe that's just maybe not take out synthetic and then add or naturally occurring. That's what we're trying to get at here, because the testimony is that the naturally occurring in hemp won't be anywhere near the 0.3. So we leave the 0.3, we're fine. We're just trying to make the simple fix that the crime lab can test for this. So we need synthetic or naturally occurring or any, but not just synthetic. So that's where we're trying to get. So let's just go with synthetic or naturally occurring.
Mr. Chairman?
It feels like, to me, that less might be more, language-wise. But let's go to the co-chairman and then Senator Case.
Thank you, Mr. Co-Chairman. So I think what I understood was that the naturally occurring is going to be present in our hemp products. And so if we now say that it's prohibited to have naturally occurring or synthesized products, then we endanger our hemp production. And so I want to make sure that when we talk about this, that we're framing this in the context of filling that hole and not inadvertently create an impediment to our hemp production for textiles and soap additives and all the rest.
Senator Case.
Mr. Chairman, I was mostly going to ask you if you think those Lander Valley High School graduates, ladies, are pretty impressive. I think they are. I think she's got a good idea. And what we want is, in the big picture, we want to be able to have a de minimis amount, undetectable amount, or an amount that doesn't cause any psychotic interaction in any product that people can buy and consume, whether that's synthetic or whether that's natural, because you can't detect the difference. On the other hand, on the stuff where we're trying to penalize it, we do need to include both, because you can't tell the difference. And she's got it. We just have to figure it out. And Representative Crago, when he says any way that it's formed, I think that works too. I think they both have a good idea.
Thank you, Senator. Representative Chesty.
Thank you, Mr. Chairman. And addressing the comments of Co-Chairman Washut, I think we solved your problem by, so this is a definition, and we're adding to Schedule 1. We're defining in Schedule 1 what is controlled, and we just say naturally occurring or synthetic equivalents in an amount in excess of 0.3 grams. And that solves your problem, because natural occurring will not ever reach that level, only synthetic would. But if we add that 0.3 here in this definition, that's what's controlled. Anything below that's not controlled.
Thank you, Representative. And frankly, I think that the 0.3 level that's been referenced by two of the representatives in different ways allows for some synthetic, let's be honest. As long as it's below 0.3, isn't that what we're shooting for here? So that, I don't know if that helps, Mr. Fuller, but that's the kind of language that I think 55 needs. And then my sense is, kind of like one of the senators said, I'm not certain that we need the other bill if we can just fix this. This is what the committee wanted to fix. And we just want it to be legal below 0.3. Does that make sense? Go ahead.
Yeah, Mr. Chairman, I think I can put a draft together that would take care of that and put language together that would do that. I would be hesitant. These are just the substances that are listed in this statute. In 1014, there's no reference to amount. And so the consideration for the committee there would be, if you put an amount in here, how does that interact with the previous bill that spells out the amounts required for criminal possession?
I get that. And you may discover as you sit down to draft this, Mr. Fuller, that we do have to get rid of the reference to synthetic modifications or, no chemical modification to be allowed. Or I hope that the conversation of the committee helps on that front. Are you comfortable that we can maybe be ready by November with something that hits at where we're going?
I think so, Mr. Chairman.
Okay. Committee, anything else on 55? Oh, Mr. Co-Chairman.
Thank you, Mr. Chairman. So the Delta 8 that we're encountering on the street today, does it exceed that threshold amount that we're talking about? And if it does, the reason it does is because it's been modified in some way, that if it were naturally occurring from the hemp plant, it would not exceed that. But if it exceeds that level of THC, is it not presently in statute prohibited?
Ms. Barrett?
Chairman, Representative Washit, could you rephrase your question?
So we're talking about changing this bill draft so that it focuses in on the THC concentration. And what I'm saying is, and I want to make clear in my mind, the Delta 8 products that we're encountering today at our high schools and elsewhere, does that product exceed this threshold that's being described? And if it does exceed that threshold, is it not already illegal under existing statute?
Chairman, Representative, currently the threshold of 0.3% applies to Delta 9 THC. I believe, without doing testing on Delta 8 in terms of how much is in the product, I believe it's above 0.3%, but currently the statute is for Delta 9 THC for that threshold.
Anything further, committee? So, Mr. Fuller, go ahead, Representative.
Thank you, Mr. Chairman. So here I thought I had it all figured out, and then I'm looking at this, and this references 6 and 8. And you're saying then the hemp goes to Delta 9. So if are you saying this, even this doesn't cover it? We still need to add the Delta 8 over in that statute that refers to the 0.3 threshold? Like, are we still missing it if not only the testing for the synthetic or naturally occurring,
Delta 8 is specifically listed in Schedule 1, we all know, right? But there is no threshold for Delta 8 currently. The hemp one is only for Delta 9. So if we removed a reference to synthetic here, so now Delta 8 would be considered Schedule 1 as, well, it already is Schedule 1.
You can test.
But we just can't test for if it's naturally occurring or synthetic. Would it be, I wonder, could we, instead of adding a 0.3% threshold for Delta 8, that we are not able to test for that right now. So that would require our laboratory to do validation. It would require time. We can do it. It's not work we're currently doing. Could we exempt in this part except as defined by hemp? I don't know. I don't know if that makes legal sense.
Yeah, Mr. Chairman.
Go ahead.
So I'll try to put all three of these bills together. The 0.3, I think Ms. Barrett's correct. That only references the Delta 9 THC, which, the component of the cannabis plant, i.e. marijuana. Marijuana is a Schedule 1 substance. It's listed in a separate paragraph, not included or changed in this bill. At the end of the Controlled Substances Act, 35-7-1063 is an exception to the provisions of that act. And currently, that language
Includes Delta 9.
So the provisions and penalties of the chapter, so the whole Controlled Substance Act, don't apply to the possession or use of hemp or hemp products for any purpose or application. That, and then hemp is defined in Title 11, which only covers Delta 9. So I think, Mr. Chairman, that may be that's kind of the circle that we're dealing in. And it's just a question of what the committee wants to exclude from that hemp. What should hemp have or not have, I think is probably the question for the committee. And maybe, Mr. Chairman, maybe I'm going off astray from what DCI is looking for, but.
Oh, okay. We've got a director of one of our agencies that we would love to hear from. And thank you all. Again, we reserve the right to call you right back up. Director, thank you. We've been working hard to get in your direction and appreciate it.
Thank you, Mr. Chairman. Again, Doug Miyamoto with the Wyoming Department of Ag. I'm hoping I can help today. So
we really hope that too.
That loophole was created because hemp was essentially taken off the Schedule 1 list, and it said all of these products that you create from hemp are now legal. And so technically they're deriving Delta 8 THC, but there's other psychoactive derivatives that could be synthesized from a hemp product. And I think what you're trying to do is get a hold of all of those psychoactive derivatives of hemp. And so I'm wondering if the language couldn't change to the disallowing of the manufacturing of psychoactive derivatives of hemp. And if we do that and just say you can't take a legal hemp crop and then try to derive some kind of psychoactive component from it and sell it, maybe we get there. Instead of trying to list out Delta 8, Delta 6, Delta 10, we can just say you can't make psychoactive components out of a hemp crop, and then maybe we can get that wording down to match in the controlled substances aspect and put a prohibition in the hemp statutes as well. We've only ever had 2 samples that came back as non-detect on any THC out of the hundreds of samples that we've taken. So THC is a natural component in hemp, and it's not all that insidious by itself. But I never anticipated the creation of Delta 8 THC either. So I can't sit here high and mighty and tell you I have all the answers, but I'm wondering if broadening that definition and just saying we're going to disallow the manufacture of psychoactive derivatives of hemp.
Doug, thank you. Representative Oakley.
Thank you, Mr. Chairman. Thank you, Mr. Miyamoto. So I think that's a good idea. The only thing, I think we've got to do 2 things. And just to be clear, I agree. I really don't think the intention was ever to do non-detectable, which would just kill the hemp. And we don't want to do that, just for everybody's, to allay some fears. But so the manufacturing is one end, but then it still doesn't get to the possession, which is when we've got our DCI here talking about what testing they can do. So I see a 1-2 where you say the Delta 9 include Delta 8 as far as this definition of the, under the 0.3 in the hemp. And then perhaps in addition, specifically prohibiting the manufacturer, because it is some kind of bad actors there figuring out the loophole and making it. But so we could kind of do the 1-2 combo there. I think adding Delta 8 to the hemp statute, which I don't think the industry would oppose that, right? Is that fair to say?
Go ahead, Director.
Mr. Chairman, Representative, I don't think the industry, I can't speak for them, but I don't think they would. You have to understand, though, from the Department of Ag standpoint, our regulatory authority only extends to the farm gate or the processing facility fence. So we're testing at those 2 locations, in the fields or at the processor, but we're not following that down to a dispensary as part of our regulatory authority doesn't extend that far. So I wouldn't want to testify on behalf of any law enforcement about how they chase that down at a retail location. But I do think, we could get a handle on being able to sample at a processor and just say you can't manufacture psychoactive components from this hemp crop. Then we could look, obviously you have to process that in order to get Delta 8 Delta 6, Delta 10, and I don't know what other psychoactive derivatives may be out there, as was testified to earlier. There's hundreds of those cannabidiols out there, and so not the right guy to ask on that front.
Anything further for the Department of Agriculture? Director, really appreciate you being here. It looks like we're not going to need you as much as we thought we were going to. At least that's going to be my suggestion here in a moment. So thank you very much, though.
Thank you, Mr. Chairman. It is fantastic to not be needed.
Yeah. So committee, I think as we draw to a close, I'm hopeful, Mr. Fuller, that you've followed the conversation, and I liked your suggestion of maybe giving it another try to combine these three bills into what we're shooting for. Any further thoughts on that? Anything else you need from the committee? We can attempt to clarify one more time, but I'm hoping that maybe we're getting there.
So, Mr. Chairman, I think the one thing that would be helpful would be your direction, perhaps to maybe work with DCI and the Department of Agriculture on language as well.
Absolutely work with those two agencies carefully. I think they've followed the discussion right along with us, and I'm hoping that we can get a little bit better cohesion and get to where we were shooting for. With that said, committee, go ahead, Senator.
Thank you, Mr. Chairman. I just want to, this is obviously a very confusing and complicated subject. I even thought at one point I heard Senator Case agree with Representative Oakley over here, and that's how confusing this thing is. But
Go Tigers.
the point being, it's the most important part of this, besides figuring out how we're going to define this, is that we protect our emerging hemp industry. And I want to be on the record of saying how important that hemp industry can be to the Wyoming as we're moving away from the cash crops we've had for these farmers in the past, such as sugar beets and whatever it might be. So that's my point. Thank you.
Well, we appreciate that from the senator of the Bighorn Basin. We, sometimes we know as legislators that we're the ones that start the fires. Sometimes we put out fires, sometimes we start them, and then we have to go back and we have to put them out. And I think I speak for many on the committee, maybe every one of the committee members, in saying that wasn't the purpose as we drafted these bills to put an end to anything on the hemp front. It was to try to fix our statutes. And so, I'm sorry that created a whole bunch of confusion and some difficulties. I think with the charge that we've given to Mr. Fuller, committee, I believe that we can end the conversation today and take it up in November with the drafting of a new bill. And we will get that effort posted as soon as Mr. Fuller can pull together. He works magic, so I'm pretty sure we're going to have a good product, and we'll get it out there so everyone can look at it. Unless there is some desire to take up the second bill, I think it'll be incorporated in November. And with that, I want to take a 15-minute break. 15 minutes. So we will come back at, let's say, 10:50. call the meeting back to order. Appreciated the discussion this morning and didn't by any means intend to cut off any of the opportunity for public input. I just wanted to kind of remind where we ended up with these topics this morning that dealt with controlled substances and the hemp in particular. We have requested a brand new bill draft, which will encompass a lot of what was debated this morning and suggested. And I'm confident that we can come up with a good product that we will visit about in November. By no means was there any intention to do away with the opportunity for public comment. We would still welcome that, but things have changed. Those two bills that we were considering this morning are not on the table anymore. And by the way, I didn't have an opportunity to represent two of our former representatives. Representative Sweeney is in the House, and so is Representative Bunky Laux. So welcome, you guys. Appreciate you both being here. Let's go to public comment. Please come forward. I would ask that you state your name for the record, and you're welcome to address the committee. Remember that we've kind of gone in a completely different direction, so welcome.
Thank you. My name is Rochelle Tabor.
And I'm David Tabor. We own Natural Wellness CBD. We were actually one of the first medicinal hemp companies in Wyoming. We started in Cheyenne about 5 years ago.
Is it David? Is that right?
David.
David? Good to see you.
We have a store in Cheyenne, Wyoming, one in Greeley, Colorado, and one in Estes Park, Colorado. We make our own products. We also wholesale, and we also have an online business. We've been in the medicinal side of CBD for, like I said, 5 years.
The reason we came up here is because you said that Delta 8 in a synthetic form would be okay. However, we've had the same fight in Colorado, and any form of Delta 8, even synthetic, is dangerous. What they're finding is that it has caused irreversible psychosis in some people. So what I want to explain is when you get the raw form, which we get, the Delta 8 is not detectable. So when they're testing and they're getting any amount of Delta 8, it is synthetic, and the synthetic is very dangerous. So I know you want to change the bill to be 0.3, and that's okay, but it's not if you're allowing any Delta 8. Colorado has banned Delta 8 completely if it is separated from the hemp plant. It is such a minor cannabinoid in the hemp plant that, like I said, when we get the raw form, it is non-existent. I have gone back to every test that I have ever received of a COA, and it has always been non-detected. Part of what your problem is that we're facing right now is you have other companies out here that are out to make people high. They are doing it through Delta 8, and they are doing it through THCA, okay? It is not hemp. It is actually marijuana. I went out and investigated what is going on. Why is this being brought up? The reason it's being brought up is because they're not selling hemp. They are doing it under hemp. And that's where I become kind of angry about it, because our purpose is to help people, not to get people high.
The Farm Bill of 2018 clearly states in there that no levels of THC can rise above 0.3. And that is the acid form of THC or the Delta 8 form. At no form can rise above 0.3. That pretty much cuts to the chase right there. You know, natural occurring hemp is only medicinal. The levels of cannabinoids in there are only medicinal at that level.
Not
you know.
psychoactive in any way, shape, or form. There is nothing in our store that can get anybody high. We want people to understand that there is a difference between hemp and marijuana. Marijuana is grown to be very rich in THC, and very little in CBD. In fact, they try to get the CBD out because it counters the high.
It does.
Whereas hemp is going to be very rich in CBD and very little THC. The problem that this state is facing is you have a lot of people that are selling marijuana under the pretense of hemp.
The Farm Bill of 2018 clearly states that anything over 0.3 should be classified as marijuana. So when you're looking at a test here that might say when they picked it when it was green, the acid form of THC might have been 29, but it's not realized until it's dried or heated. So it's one of the other ways they're getting around a little bit too. But if any form of THC is over 0.3, then according to the Farm Bill, that's classified as marijuana. It's not even a hemp product anymore because it has to be modified to get to those levels.
Rochelle, I've got a quick question, if
Sure.
I could interject real quickly. All along, I've not completely understood what it takes to set a corner store, as you have done in Cheyenne, for example. You had to get state permission through the agriculture department, I assume. And then you had to get permission from the city of Cheyenne in some fashion, I'm assuming, right? So
Right.
you've cleared 2 hurdles. Does that pretty well cover it? You probably had to pay some taxes along the way?
Yeah, the difference between Cheyenne and Colorado is we're actually required in Colorado to have a COA on all of our products, which makes it easier for the law enforcement.
What's a COA?
A COA is a certificate of analysis.
Oh, thank you.
And there's,
So,
and really what there is, there's 2 of them. There's one for potency and then one for contaminants.
correct.
Okay.
And so we've worked with the police department, and I've even talked to Sheriff Kozak about what's kind of going on. And I told them that I would work with them as far as, honestly, a bill needs to come forward that they need to have a COA for every product that they have. This is going to help law enforcement know that what they have is legal or not legal. A lot of what you have right now is illegal, and that's even defined in the hemp bill, that what they have is illegal.
Well, and Rochelle, thank you. David, that's exactly why the committee has taken this back up. We know we've got some issues out there, and really appreciate you coming all the way up to testify today. Committee, any questions? Go ahead, Representative Oakley, and then Senator, back to you.
Thank you, Mr. Chairman. And just very briefly, thank you guys for coming and testifying and actually, just solidifying, like with your testimony about Delta 8, that, that's really what we're trying to do is just get figure out how we can hold accountable the making Delta 8 used as a psychoactive drug. That's literally all we're trying to get at, and not, specifically not, do anything that would interfere with your business. So thank you.
Senator Cooper.
Thank you, Mr. Chairman. Folks, do you maintain a COA on your products in Wyoming, even though you don't require to?
I'm sorry?
Do you maintain a COA on your product in Wyoming, even though you're not required
Correct.
to?
Definitely.
Correct.
Our website always has our testing on there of all our products. It's very important that people understand that a natural product like that does not have contaminants, is not tainted by THC, because if you have CBD isolated, which is 100%, if you get stuff that's mostly out on the market is about 98%. The rest of them is contaminants, alcohol, and THC. So we're organic, so we're 100% pure, but we definitely carry a COA with us at all times.
What's the name of your company again?
Natural Wellness, CBD. So to kind of clarify that, so there are things out on the market that are not pure, like my husband was saying, where it's CBD, but people are testing hot. The reason being is because it is not pure and it actually has some form of THC in it. And that's why we're suggesting that we start implementing a thing where companies do have to have COAs so that the consumers can see how it tests out, so they can make an informed decision if they want to take it or not.
Go ahead, Senator.
Thank you, Mr. Chairman. So can you tell me just the basics, what is the process to get that COA? How do you go about getting it?
So we have a third-party lab that tests all of our product. So when we get our raw product, because we don't actually grow the hemp, so when we get our raw product, it comes in tested, and then we make it into a product, and then we have a third party that tests it, which is a lab.
Further questions? Rochelle, David, thank you. I really
thank you.
appreciate you guys sticking around and great testimony. Really helpful.
Thank you.
Is there anyone else in the room that wishes to testify on our conversation this morning? Come on forward, please state your name for us for the record. Welcome.
Thank you, Mr. Chairman. My name is Corden Butler. I'm with Wyoming Hemp Co-op, representing them to have the discussion today. A lot's been talked about. I'll try to bring up some new topics. First thing is, what are we really talking about here? We're really talking about protecting the public and our children.
Close to the microphone.
I'm sorry. Yeah, I apologize. Nobody gets high from smoking industrial hemp. A kid can go out, pull a couple fields from a field in Torrington. He's not going to get high. He's going to get a headache. That's really not the problem. I could probably throw a rock really hard from here, and there's some marijuana around this town here. That's really not the problem. The problem is these synthetic chemicals coming in. We're talking about Delta 8. Delta 8 is only one of a few. Right now, there's licensed in this country to sell Delta 8 through Delta 16. They keep changing molecules a little bit at a time. Delta 8 is the weakest of them. There's compounds known as HHCO, THCO, HHC that are very intoxicating, and actually have very little to do with cannabis. In fact, most of them, there's only 3 labs in this country that make Delta 8 in these things, because it's hard to make. You can make meth in your kitchen. Not good meth, but it's meth and dangerous. You're not making Delta 8 isolate. It's very expensive. Those labs don't even sell in this country because it's not cost effective. 98% of what we're seeing in the stores our kids are taking is coming from China. And it's synthetic chemicals. In order to make that, you don't even actually need cannabis. Some of it's made from petroleum. These are purely synthetic chemicals. Just stating this out there as information. That's why this whole regulation needs to really be looked at hard to what we're really going after. Industrial hemp is not, in my opinion, the problem. That could be a great boon for this state. Somebody growing a pot plant in their backyard, they're not making Delta 8. It's actually hard to grow good, strong cannabis. Easier said than done. Your average hippie who's doing it, it barely gets them high. It's not the problem. Fentanyl is a problem. The fact is, a lot of the same factories that are making fentanyl are making these same chemicals, coming from the same country. Curious. I looked up on Google while I was sitting here. We all know Google. Let's see what Google says. We're talking about cannabinoids, and it comes from cannabis plant. It's quite the in-depth scientific field. According to Google, other plants that contain cannabinoids to include THC are clove, black pepper, anissia, broccoli, ginseng, and carrots. So with a law that says any THC, so if I grow carrots in my yard, it has some THC in it. And studies have shown in order for you to get an intoxicating effect from THC, it's got to be 6% to 12% to even have any kind of feeling. So 0.003 is not intoxicating at all. You can get marijuana in Colorado in some places that are up to 30% pure now. Very, very strong, very intoxicating. It's very expensive, hard to grow. There's some pot plants that someone grows in their backyard. If they do a really good job, they might get 12. Man, they did a good job. Barely gets them high. You know, it's not. These synthetics are a whole different subject, a whole different category. The smokable plant that they buy, they say is Delta 8 in the state. What it is, it's hemp that is just hemp flower, less than 0.3, and they put powder on it, synthetic powder. So it's not Delta 8 hemp. It's a hemp plant that's had Delta 8 or whatever chemical added to it. And a lot of these things are labeled as Delta 8. Honestly, they're not. If you really look at it, they're combined with other things, THCO and things that are much more intoxicating, that there's no studies on. Because this is all being made up as we speak. So I just wanted to bring those points out, and the fact that the hemp industry is burgeoning in this state, and how things are worded is very important.
Mr. Butler, appreciate it. Great testimony. I think hopefully everyone understands where the committee was trying to go with this.
Yes, sir.
And appreciate your help in doing it. We're gonna try to have it right and get it right in November and onward. So thank you.
Well, thank you. I'll conclude my comments, and thank you for listening.
Further testimony from anyone in the room? Alderman? Good to see you.
Good morning. How y'all doing?
Please state your name for the record for us.
Sure, my name is Kyle Gamroth. I've been trying to follow along your discussion throughout the morning, but I'm at work today, so it's, I apologize, I've been distracted. So hopefully this all makes sense and kind of in line with what you folks have been discussing this morning. Chairman Landon, members of the Joint Judiciary Committee, thank you for your service and thank you for the opportunity to speak to you this morning. Again, my name is Kyle Gamroth. I'm one of the city council members here in Casper representing Ward 2, but today I'm speaking to you today just as a private citizen. I've been listening to your testimony this morning, debating the difference of, hemp versus cannabis and different THCs compared to each other, and how to restrict the use of THC while preserving the ability to manufacture and use hemp. And I appreciate that discussion, and thankfully there's lots of folks here in the room that can speak much more intelligently about hemp and agriculture than I can. But if you'd entertain me for just a few moments, I'd like to explore this issue a little bit more deeply. Cannabis criminalization as a whole was never based on any scientific reasoning or rationale. Instead, it seems to have coincided with a rise of racist sentiment against Mexican immigrants in the 20s and the 30s. Certainly, nobody on this committee believes the claims of reefer madness and other propaganda used at the time to justify its criminalization. If you haven't watched the film, I would encourage you to do so. It's pretty absurd in its claims and does not hold up well with time. So if the logic used to make it illegal in the first place isn't sound, what reasons are there to keep it illegal, then I wonder? If the intent of keeping a drug's usage illegal is based on the level of danger that it presents to our society, then alcohol should absolutely be criminalized to a greater extent than cannabis. There's not a single metric I can think of in which alcohol would score as less dangerous than cannabis. Here in Natrona County, alcohol is involved in 80% of our traffic crashes, 25% of domestic violence incidents, and 38.5% of overall crime. DUIs and public intoxication account for half of all custodial arrests in our state, and in Teton County, 84% of all crime is alcohol involved, 84%. Other drugs, 7.3%. This is according to the 2021 WASCOP Alcohol and Crime Report, and I do believe you've heard from folks representing the Sheriff and Chief of Police this morning. If an individual consumes too much alcohol, they could die of alcohol poisoning. If an individual is dependent on alcohol and suddenly stops, they could die of withdrawal. When I worked at CWCC, which is the community mental health clinic here in Casper up at the top of the hill, we surveyed every resident that came into our residential substance abuse program. 9 out of 10 times, their preferred drug of choice was alcohol. However, despite this, just last session, the legislature passed bills expanding City of Casper and other municipalities' bar and grill licenses, allowing us, the City of Casper, to go from 13 bar and grill licenses to 27 over the next 5 years. That's a doubling. Our own city council has expanded operating hours for alcohol establishments, implemented an open container ordinance downtown, and shown other favorable actions towards the alcohol industry. Yet Wyoming is one of the last 7 states that have not legalized medicinal cannabis. I'm sorry, but that's hypocrisy from all involved bodies, as far as I'm concerned, and when you take into account the research. 10 years ago, 14 area Casper residents ended up in the hospital with kidney failure, including 1 Natrona County School District student after smoking blueberry spice. When I worked at WBI, which is the local psychiatric institution here in town, I met adults who had ruined their lives, causing permanent delusions and disability as a result of smoking spice. When I was at the counseling center, one of my male teen clients continually abused spice despite having multiple seizures because it was a legal alternative to cannabis and he could pass his drug tests. We as a society are very familiar with the effects of cannabis and THC on the body. It's been around for a long time. Inhaling smoke from a burned organic substance isn't great for your lungs, regardless of what it is, and cannabis can certainly be abused to the point that it has an overall negative impact on a user's life. But stacked up against the rest of the drugs, it's near the bottom regarding its impact on health and detriment to society as a whole. By criminalizing its use, or continuing to criminalize its use or making the penalties even stricter, you're incentivizing the market to develop alternatives such as Delta 8.
Kyle, we do need to wrap it up here pretty soon.
I understand. I guess I'll skip a few points. What I believe is really the crux of my argument is that we need to take a constitutional approach to this. Article 1, Section 7 guarantees that no arbitrary power over the lives, liberty, and property of free men exist in a republic. Because of the arbitrary drug laws in our country, I would make the argument that it is arbitrary power. Section 114 prevents the use of criminal or unusual punishment, which I believe incarceration is, in regards to personal use and possession of drugs, including cannabis. And then finally, Article 1, Section 15 guarantees that the penal code shall be framed on the humane principles of reformation and prevention, which I do not believe it is not, is very much geared towards incarceration. Since 1980, our population has risen 20%, but our prison population has increased 400%. Our sentences are longer and they're being handed out to more people. Insanity is doing the same thing over and over and expecting different results, and I wonder, how long are we going to continue taking this approach to drug use, crossing our fingers, hoping for a different outcome before we accept the fact that what we've been doing is not working and that we need to change our approach to handle how we handle this issue. Thank you so much for taking all your time. I know you have a full agenda for the rest of the day, so I appreciate the opportunity.
We do, Kyle. I'm sorry to interrupt, but we've got a long way.
I understand. You're already behind schedule.
Drive home. So thank you. Appreciate you.
Of course.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. Gamroth?
Yes.
Yeah, thank you. So you mentioned that you were previously employed at two state-funded centers, one being a mental health center and one being a substance abuse center. I'm just curious what your credentials are.
I have a bachelor's in psychology. I wish my guidance counselors would have told me a social work degree would be a lot more valuable to me. But so just a bachelor's in psych. I was a case manager and job coach up at the counseling center for a few years. I worked residential adolescent unit at WBI for a couple years, and then at a very short stint at Natrona County Public Health Department doing substance abuse and suicide prevention.
Thank you, Councilman.
Thank you.
And thank you for your service.
Of course, you as well. Travel safe.
Community. I'm going to entertain further testimony, but I would ask that we stick to the topics, which is the hemp products. We did take up controlled substances, some modification to our statutes, but primarily 2 hemp bills. And I'm happy to take further testimony, but as I said, we are going to take that up in November. So anybody else in the room want to come forward? Okay, do we have anyone online? I'm going to allow a little bit of testimony. I would ask that people be brief and get to the point because we've got a long ways to go.
Mr. Chairman, we have 4 folks who have raised their hand. We'll start with Marcus Jones to start.
Mr. Jones? You're welcome to take it away. Please keep it as brief and to the point as you can.
I will. Thank you for giving me the chance to speak at this committee and hearing me out. City Councilman Kyle kind of hit a lot of the points that I was going to touch on. But what I would really like to touch on now is the fact that touching on the synthetic creation of synthetic products right now, technically considering CBD isolated products would be considered synthetic product based on their process to be made by isolating down all of the CBD to get it to an isolated powder to be able to have that in there. That would be considered a synthetic product just due to how that process is done. On the synthetic process of Delta 8, it is used, I'm going to butcher this, P-tolfosinic acid. It's used in a lot of pharmaceuticals to create the pharmaceutical drugs that were needed. That is the chemical that's used to create Delta 8. And so it's not a synthetic, but it is synthesized from CBD. My next point would be that if you do want to ineffectively ban Delta 8 as a representative of the community, the best route for that would be to decriminalize marijuana altogether, and you would see the sale and production of Delta 8 disappear almost instantaneously. The whole reason Delta 8 has been created or has caught on with so much popularity is because of the ongoing prohibition against marijuana. This was a loophole to give the community what they want, and we've seen a huge rise in people wanting cannabis-related products. And this was the option for them. If we were to decriminalize in the state of Wyoming and give the sale of even medical or recreational, if we went that far, that would inadvertently destroy the Delta 8 market because there would be no need for it. So then we would no longer need synthetic cannabinoids to get around the laws. One of the other big things is I don't think we should talk about banning more than we should talk about regulation and what the packaging should be done, how we should keep these away from our children, because even though I work in the cannabis industry, I am the operations manager for Platt Hemp Company. I do believe that adolescent use of cannabis has shown that it has a detrimental effect on prolonged learning and memory and behavior. And so I do not believe that THC should be allowed for children, but we need to put regulations in place to allow adults, if they want the choice to use those products, to be able to allow to use them, but keep them out of the hands of children is my bit.
Okay, well, thank you very much, Mr. Jones. Appreciate you sticking around, and thank you for your testimony this morning. We're going to
Thank
move on through. Do we have others waiting?
Mr.
Clarissa,
Chairman.
please let the next person in.
We do. We have Sam Watt next and then Shane England.
Okay, Mr. Watt, I see where you represent the same company as Mr. Jones. Anything else to add that Mr. Jones has not stated this morning?
All right, sorry about that. The reason why my wife and I, Alicia, we opened our company is to help me with a lot of problems that I've came about during my military career. And so I have a severe case of PTSD. Prior to that, I was taking opioids that the VA has issued me, 7 of them to be exact, and 3 of them are narcotics. I got addicted to it, treated it with alcohol because there was no resources at the time for my condition. Since then, I have quit all my prescriptions except one, and then I use the hemp products to battle my PTSD. And so far, the last 3 years, I haven't had one issue. So there it is. It is proof in the pudding that this product is something that a lot of people can use, especially our veterans, because still there is not a whole lot of treatment out there for us. And I think it's important to take care of our veterans. Besides that, yeah, there's a whole lot I could talk to you guys about, but since you tabled it, I'd like to be part of the committee, for information, because like I said, we have 5 stores across Wyoming. So if our success, there's got to be a reason for our success, and it's because of what we do is correct. That's it.
Mr. Watt, thank you, and thank you for your service. We appreciate it. We look forward to the conversation as we move along. Thank you very much. Next up, Clarissa.
Mr. Chairman, we have Shane England next.
I did not catch the name. If you would please introduce yourself and keep it as brief and to the point as you can for us. We've got a long day ahead of us.
Well, thank you, Mr. Chair. This is Shane England. I'm a owner of a company that established a business in Sheridan, Wyoming last year under the name of Yellow Hemp Co. And then since then, we've opened up a retail operation over in Evanston, Wyoming as Wild Cannabis. So it's got some attention lately. And my background has been heavily in medical. I'm a warrant officer in a medical unit for the U.S. Army and was so for over 30 years. So I've got a quite extensive background in medical and psychiatric care as well, being a counselor. So cannabis has been one of those things that have really intrigued me over the years, and I've done some heavy research into it and found that obviously the hemp industry's been probably the most robust application of medicinal cannabis on the market. Honestly, there is no difference in the textbooks between hemp and marijuana. They're all cannabis. So we're really talking about the legality of one side versus another. So my proposition, I'm part of a hemp association that's fought a lot of these hemp bills throughout the nation under Hemp Industries Association out of Texas and Washington, D.C. And we're very interested in seeing the hemp market preserved, including all the THC analogs that come with it, which I've got to set the record straight on the hemp bill. The only THC controlled substance on the hemp bill is Delta-9 at the 0.3%. Every other THC analog is considered under the hemp purview. So I just want to set that straight. And my goal was to come to this committee meeting with the agenda to help us look at this bill and maybe table it, which I'm glad we have, and put together a subcommittee of stakeholders and public servants that can look at how to better regulate the industry. That's been the goal. And I concur with a lot of the points been brought up. Age limits need to be put in place. Safe testing of all of the full spectrum hemp extracts need to be done, including looking at the science between Delta-9, Delta-8, and all the rest. Honestly, we've had good success in the scientific community with Delta-8 because it actually decreases anxiety, whereas Delta-9 increases. So there's a practical application to using Delta-8 versus Delta-9. And of course, there's other isomers out there that need to be looked at. So I'm looking forward to helping structure some conversation in a committee type format that would allow us to come together as, like I said, public servants and stakeholders to implement better rules. And other considerations I think we have is not making a new class of criminals out of patients, because we've got patients going to Colorado and Montana that bring back federally illegal cannabis, obviously from those states. And now we finally have something legally available in Wyoming. May not be marijuana, but it is hemp, and it does allow for patients to get the relief they need. And I would hate to see a new class of criminals made out of those patients. And then I'd hate to see a more robust black market being made out of the hemp industry. So those are things I'm hoping to avoid. And considerations we might want to look at too, as the DEA is coming out with new rules on the hemp analog question. All the THC factors are there, along with the new hemp bill coming from Congress. So there's a lot of things coming down the pipeline this year and next that would heavily influence what's happening in the marketplace. So I think we need to defer to those and look at what's going on there before we make any hard decisions. That's pretty much the crux of what I wanted to testify on. Thank you for your time.
Thank you, Mr. England, and thank you for your service. I believe we have one more waiting.
Mr. Chairman, I don't see anyone else with their hand raised, but I'd just ask one more time. Okay, it looks like Dustin Smith has raised his hand. Mr. Chairman, he'll be joining shortly.
Okay, Mr. Smith, hailing from Senator Schuler's neighborhood.
Hello, sorry I had to pull over.
I would ask you to
I just wanted to get on
please be as
here
brief
and
as you
say
can.
that,
Sir?
I don't know if you guys are aware of who Raphael I'm butcher's name, but it's Raphael Meshulam. He's studying cannabis at the University of Israel. He just passed away, but he's studied it since the 1950s, 1940s. Delta-8 was first discovered in the 1960s, and there's a plethora of scientific knowledge on it. The fact that anybody's saying it's a Schedule I substance, that's a fallacy. We have DEA documents of their opinions and everything that counter that. Another issue you guys are going to run into that you'll find is the interstate commerce protections. If you guys legalize this stuff, people are going to buy it offline, and it's just going to come into the state that way. And then you're going to make people criminals for acquiring a legal product from a federally legal venue and it's going to be a bad situation. That said, I do appreciate you guys' concern for the children. I do agree that there needs to be age limits. There needs to be testing. There needs to be processes put in place. I think reiterating what the gentleman before said, in order to create an isolate, you have to wash it with gasoline type substances. Mr.
Mr. Smith,
the isolate itself,
we've covered
the CBD
a lot of what you're going to.
is by your own definition a synthetic. So you would just be
Sorry,
destroying.
Mr. Smith, we have to move on. I appreciate you taking the time, but we've got a lot ahead of us, and we've kind of covered where you're heading. So really appreciate it, Mr. Smith. Thank you. Committee, we're going to move on. I think that's plenty of testimony on things we haven't done or might do in the future. So we've got a lot to cover. Let's move on to, let's go back to the Wyoming Attorney General's office. And if you'd like to come forward, I'd ask that Mr. Fuller, can you walk us through LSO 56, sex offender registration, registerable offenses?
Yep, Mr. Chairman. And before I do, Mr. Chairman, just maybe one note on the schedule. The committee was to hear from Mr. Quigley at noon. It's my understanding that he has a pretty firm schedule over the lunch hour, and he'd need to leave by 1. So I just want to kind of put that on your radar, for the committee in terms of timing.
Thank you very much. And Larissa, if you can help me keep an eye on that, we'll gavel out appropriately. So thank you, Mr. Fuller.
So, Mr. Chairman, 24 LSO 56, this is working draft .4, 13-04 on the meeting materials. This is a draft that the committee requested after hearing testimony from the Attorney General's office, and it adds offenses for which convicted offenders must register as a sex offender, and then it also repeals a definition in the sex offender statutes that appears to be the only place where that term is used. Mr. Chairman, the staff comment on page 2 pretty much outlines what's happening in the bill. So 3 offenses are added to 719-302G. That's on page 2, lines 29 to 33. And the 3 offenses that are added to this subsection, which requires annual registration, are sexual servitude of an adult, felonious restraint, only if the victim was a minor and if committed by someone who was not the parent or guardian of the victim, and then false imprisonment, only if the victim was a minor and if committed by someone who is not the parent or guardian of the victim. Then in 719-302H, this is page 4, line 3, this requires semi-annual registration, sexual servitude of a minor is added to that provision. And then page 5, line 16, inserts first degree and second degree human trafficking in the subsection that requires quarterly registration. On page 6, line 22, 719-301A4, which is the definition of criminal offense against a minor, that is repealed, and that definition does not appear to be used elsewhere in the article concerning sex offender registration. And then this would be effective July 1, 2024. And then, Mr. Chairman, you also received information from my colleagues, Ms. Adams and Ms. Nord. There was a question at the last meeting regarding false imprisonment and felonious restraint and their inclusion in SORNA. And there's that information that you have outlines how that ended up being removed from Wyoming SORNA statutes in, I believe, 2011. So just wanted to highlight that you have that information as well. With that, Mr. Chairman, I'd stand for questions.
Committee, any questions on LSO draft 56, sex offender? Okay, let's go to the Attorney General's office. Welcome again. Thank you for being here, all 3 of you. Walk us through the reasoning behind this bill, please.
Thank you, Mr. Chairman. Again, my name is Kelsey Singleton, and I'm with the Wyoming Attorney General's office representing DCI. I also have with me Allison Moore, Deputy Director of the Criminal Justice Information Services. So if you have questions about the sex offender registration program itself, she's happy to answer those, as well as Kara Chambers has some information about some of the previous sex offender bills that were passed recently. I think one thing that has come up in the past with including felonious restraint or false imprisonment on the list of registerable offenses was the concern that a juvenile could be prosecuted for this and the concern that a juvenile would have to register for that offense. However, in this amendment, both of those offenses are listed as G offenses. And under the definition of convicted, a juvenile does not have to register for a G offense, only if it were a J offense. So there is no concern here in this amendment that a juvenile would have to register if they were convicted of felonious restraint or false imprisonment. Certainly, I think I would just like to emphasize that DCI does not have a preference if felonious restraint and false imprisonment need or need not be included. We just needed some clarity because it was included in 719-301 in our definitions section, but not included in 302 under the offenses that were listed as registerable. So DCI wanted to ensure that we were requiring certain offenses to be registering and others not. And I think this amendment, thank you to LSO, does that for us. So certainly the rest is within your discretion, what you want to be included in 719-302. The removal of those definitions helps create that clarification, and I'm happy to answer any questions.
Questions? Any questions? Okay. Thank you very much.
Thank you.
Appreciate it. Anything else from either of your colleagues? Okay, we'll reserve the right to maybe ask a question a little bit later. Do we have anyone else? Maybe the peace officers, folks. I'm looking back at Chris on the standards and training. Maybe Sheriff, who do we have?
Sure, Mr. Chairman. I think that those last bullet points are a different topic.
Okay, thank you. My mistake in looking at the agenda. I'm just trying to see if there's others who want to testify on 56, the sex offender registration bill. I know we have one online waiting. Is there anyone else in the room that would like to testify on draft 56? Anyone else? Okay. Clarissa, do you want to let?
Yeah, Mr. Chairman, we have Maddie Morgan online as well as Jason Hansen.
Okay. Let's go to Maddie Morgan first, and then we'll come to Mr. Hansen. Okay. So
Good morning.
Ms. Morgan, good morning. Thank you for being here.
Thank you for allowing me to be here. So my testimony fits both sex offender registry and internet crimes against children, but per the recommendation of Mr. Fuller, I've decided it would be better to share now. So whenever you guys address internet crimes against children later, please keep my testimony in mind. So again, my name is Maddie Morgan. I am currently a senior attending Marshall University in Huntington, West Virginia. I believe I emailed all of you my story and why I'm interested in matters of your legislature. But in case you missed it, I'll give you a quick summary. When I was 12 years old, I was approached through social media by someone posing as a 16-year-old boy living in my state who turned out to be my 31-year-old youth pastor. For those of you that don't know what grooming is, it is when someone builds a relationship, trust, or emotional connection with a child or young person so that they can manipulate, exploit, and abuse them. So I was subsequently groomed for 2 years by this man before he was arrested and convicted of West Virginia Code 61-8A-2, distribution and display of obscene matter to a minor. To be specific but general, because I don't want to be too vulgar on this video. On several occasions, he sent me nude photos and videos of himself performing obscene acts, not to mention the conversations he would engage me in revolving around sexual matters. He was required to register in my state as a sex offender for life. And I'm speaking for you today because he is now a member of your state. He is a father of young children, a church member, and most importantly, he's a convicted felon of a sex crime against a minor in West Virginia. Since he left West Virginia upon release from prison, he was relieved of the registry requirement and he was told to comply with wherever he was moving to. After speaking with DCI and the Attorney General's office on several occasions, they have informed me that Wyoming does not have a crime on the registry, and it is my belief that you don't have a crime in general equivalent to what he's convicted of here. So therefore, he cannot be held to the lifetime registry requirement that I was promised as a child. Even though I was promised justice, I do not feel that justice has been given to me since he found a loophole in the registry. It's important for me to note that I was a heavily involved member of this church whenever he was grooming me, and I would argue that he used his position to take advantage of me and other girls that were mentioned in the indictment. He is a heavily involved member of his church since moving back. He was recently a featured guest on a podcast for this church. He's in a church, he's reestablished himself. His children are quickly approaching the age I was when he started grooming me, and there's no law in your state to prevent him from doing this action again. This is enough for me to come out and say that everyone needs to hold him accountable for what he did. I also think it's worth mentioning that if he found a loophole and that he could move away from the state where he was convicted, that there are others that have done the same thing and found a loophole. So I'm trying to look out for potential victims that could be similar to me in your state. So I want you all to change the law. I would like for you to add an offense written closely to West Virginia -61-AA-2 and to make this offense eligible for the sex offender registry. 31 out of 50 states have laws similar to the one he's convicted of in West Virginia, and 17 out of 31 of those laws are available on the sex offender registry. I understand that not all of us think the same, but I think that we all agree that we want to protect children. Children are approached every day by predators using similar disguises and facades, and a lot of the time they're not equipped with the knowledge to fear these predators. Grooming is almost always a precursor to assault and abuse of children, and this law would criminalize such behavior. If you guys were to implement laws similar to West Virginia -61-AA-2, we can keep predators from sending obscene messages and matter to children, and we can get ahead of these children being groomed or worse. I believe I sent you all documents in my case, and I think that the document about the laws in my state versus yours was published to your website in the meeting materials. So if I can be of any assistance to you in adding that in the future, I would love to help out. But again, I thank you all for your time, and I thank you committee members who emailed me back when I sent you a long, lengthy email with more details about my story. But I hope you'll consider the facts of my case and the accessibility of the internet to facilitate crimes against children, and decide moving forward that criminalizing this sort of conduct is an important matter, and making those laws eligible for the sex offender registry in your state would be an important thing to do. Thank you.
Ms. Morgan, thank you very much. Appreciate you taking the time and making the effort. It counts, and the committee appreciates that. Any questions for Ms. Morgan? Any questions? Thank you again, Ms. Morgan. Much appreciated.
Thank you.
Okay, let's go to Mr. Hanson. Good morning, Mr. Hanson. If you'd unmute, state your name for the record for us, please.
My name is Jason Hanson. I'm here today on behalf of a group of citizens to ask this committee to fix a mistake in the Wyoming's current registry laws, 7-19-302, which you're looking at amending with the bill 24 LSO 56. I would just like to thank you for all letting me attend virtually, and forgive me for my nervousness, as this is the most guests I've had in my house before, and I will get right to that. I think we can all agree that this is an awkward subject to be discussing, one that has an exhausting amount of information to try to digest, with many implications for the entire population. That's why as citizens, we rely on you, our lawmakers, to look out for the best interest of all citizens. In turn, our elected officials have chosen to rely on the knowledge of the Legislative Service Office and delegated the construction of the framework for the sex offender registration statutes to them. I understand the need to do this as they are trained lawyers. They generally have an objective intent. But when you've delegated a task and a mistake is made, I believe it becomes your duty to fix it. To err is human. The LSO office members, the members of this committee, of Senate committee, also the Senate committees in the past, they're not exempt from this. And in 2007, when the Wyoming sex offenses were classified into the current 3 levels of severity, the low, medium, and high, they determined their reporting habits. A mistake was made at that time. At that time, statute 6-2-316A third degree sexual abuse of a minor, a nonviolent situational offense with victims that are 16 and 17 years old, was placed into the severe J category. All other offenses in this J category are violent or have victims under 13, except 6-2-316A. This low-level offense, they're required to report 4 times a year. They may never ask to be relieved from registry duty, and they're communicated to the public as severe sexual offenders. They're subjected to a fine every time they report. So 4 times a year they report and they pay a fine. There are numerous categorically worse 1st and 2nd degree offenses that are placed in the medium category H, only requiring those offenders to report 2 times a year, and they may ask for removal from the registry after 25 years. They're also not, in some jurisdictions, communicated to the public as sexually aggravated offenders like the J category is. For example purposes, if you had a 22-year-old that had a relationship with a 16 or 17 employee of theirs or a student of theirs, they would have been in a position of authority, and they would have been charged with 3rd degree sexual abuse of a minor, that's 6-2-316A. They would have to report 4 times a year. They would also be communicated to the public as aggravated sexual offenders. Whereas if they had had a victim that was 13 through 15 instead of 16 or 17, they would be put into a 1st degree sexual abuse of a minor, 3-14 A III. And that would be, they would only have to report twice a year, and then they could ask to be off the registry after 25 years. This is unconstitutional in every aspect. It does not treat all citizens equally, nor does it protect all citizens from Wyoming's laws equally. It does not show a penal code framed on humane principles of reformation and prevention. It is not a law that performs uniformly. It does not give citizens free and open access to state courts to address their injuries. And it deprives citizens of liberty without due process of the law. Imposing the maximum regulatory burden on these low-level offenders seems arbitrary at best, not to mention cruel and unusual punishment. Wyoming Sex Offender Registry's stated purpose is not to punish, but to facilitate law and the protection of children. I think it clearly goes against the protection of children to incentivize offenders for choosing younger victims, 13 to 15 in this case. The severity of these offenses, they were determined when they were given statutory degrees of order. Clearly, a 3rd degree offense is a less severe offense than a 1st degree offense, especially when it's a comparable offense given when a victim is younger. Therefore, the registration requirements for the 3rd degree offense should not be made to exceed that of the 1st degree offense. Since this committee is already revising Wyoming sex offender registration statute in this bill by adding new statutes to its tiering policy, and thereby will be reenacting and publishing it at length in accordance with Wyoming Constitution Article 3, Section 26, I would like to request that the committee direct the LSO office to amend the categorized level of statute 6-2, 316A II, third degree sexual abuse of a minor, retroactively to affect all current registrants and future, so as to be more in line with the legislator's stated purpose of classifying sex offenders into tiers based on severity, and Wyoming's registry stated purpose of not being to punish. Relief from duty is not automatic, nor is it guaranteed. It's up to a district court judge. All I'm asking for today, and there are 26 individuals that this currently affects for this statute, is the opportunity to have that relief, that opportunity to speak with a judge and have him hear the facts of each individual case. We're asking you today to fix a mistake that for over 16 years has been requiring these low-level offenders to over-report. These clearly low-level offenders, they should have that opportunity for judicial review process. This is especially true now that recently the Supreme Court of South Carolina ruled that lifetime registration for low-level offenses without a chance for judicial review is unconstitutional, citing Powell versus Keel, South Carolina, 2021. Some crimes, they're so serious, they require lifetime registration. As a father to teenage daughters, I understand that. But there are clearly crimes that are an obvious lower level. As average citizens, some of us, we don't know the laws. We don't know the complexities in making them. But we can generally tell right from wrong. And there's something very wrong with requiring low-level offenders to register twice as often as an offense where if they had just chosen a younger victim, they could get off in half the time and be able to ask for relief from duty to register at some point. I know it's easy to hear the word sex offenders and think everyone's a monster, but some of these individuals, they've just made terrible mistakes. They've served their time. And in the case of statute 6-2, 316, they've been monitored twice as often as more severe offenses. I've heard it said in this committee that the Wyoming legislators believe mandatory lifetime registration only applies to the most serious sex offenses. I pray that I've shown you that this is not the case. And I again ask the committee to direct the LSO office to retroactively change the reporting requirements for statute 6-2, 316A II, third degree sexual abuse of a minor, to a more appropriate level. In an effort to cut my time short, I had planned on sharing my personal story. If you all feel that I've made my point enough, I could save that for another legislative meeting. But the fact of the matter is this law that you're trying to amend with this bill is unconstitutional. And any part of a bill, any part of a law that's any part of a statute that's unconstitutional, the statute as a whole is unconstitutional. So for you to amend an unconstitutional bill, you're essentially putting an unconstitutional bill through the process. And Wyoming Constitution, Article 3, Section 20 says no bill shall be altered on its passage through either house as to change its original purpose. And no matter what you do, statute 7-19302 is treating these offenders on this third degree offense punitive rather than procedural. I'd like to thank you all for your time, your effort, and allowing me to speak.
Mr. Hanson, thank you. You've obviously done a lot of work on this front, and we will take that under advisement. Appreciate you taking the time. Any questions of Mr. Hanson? Okay, thank you very much. Larissa, does that do it on those who would like to join us online? Okay. I'm going to close public testimony. Committee, what's your pleasure on this bill? What is the pleasure on the bill? Do we have any desire to take up sex offender registration registrable offenses?
I'll move the bill.
Mr. Co-Chairman has moved it. Do we have a second?
Second.
Seconded by Representative Rodriguez-Williams. Discussion. Mr. Co-Chairman, then we'll go to Representative Carrollton.
Thank you, Mr. Chairman. I guess I'm curious why the rest of the committee is not interested in moving the bill. It seems that we had a request before us to clarify some language in existing statute, and witness testimony was that this bill draft accomplished that. And so I'd be just interested in why others are not as willing to embrace this.
Representative Harrelson.
Thank you, Mr. Chairman. So I obviously, I believe that we do need to have this conversation, do need to move this bill forward, and maybe to answer the good co-chairman's question. We just had two very different, very interesting conversations from testimony from individuals saying, hey, we need to address other issues. And so I think we do have a draft in front of us that does clarify, but I think in some ways we've had other questions brought forward that we need to probably look at and make sure that we are properly protecting, but yet at the same time not unjustly doing, is what we've seen in testimony here today. So is there a loophole that individuals who are predatory in nature and grooming are not being addressed, and we have an area of our statute that we're not protecting those that need protected, and at the same time, I think that we just had an excellent testimony that stated, hey, maybe there is a bit of a miscue that needs to be shored up. So I think that as we have moved this bill, that's excellent, but maybe some more work needs to be done.
Okay, thank you, Representative. Representative Oakley.
Thank you, Mr. Chair. So I admit I feel like an idiot that I cannot figure this out, and there's a memo on it. So I guess I'd like to hear from Mr. Fuller, our rock star. So I guess it's because it's required under SORNA. I do not understand. I still I'm confused. And it appears that on page 2, we're continuing to include this 62202, for example. So felonious restraint and false imprisonment because they're kids, but including it in the sex offender registry. And I'm just confused about that. And then I know obviously then later we take it out of the definitions of 719-301, but I guess I'm just not following, and I know I should be able to.
So, Mr. Fuller, can you help us with that and just reiterate exactly what the bill does? That would really be helpful.
Yep. So Mr. Chairman, I'll start with the bill. And I'll focus specifically on felonious restraint and false imprisonment. I think that's where the question was going. So this bill would add felonious restraint and false imprisonment, in essence, back in the SORNA statutes. The inclusion here comes with a qualifier, though, in that either of those offenses, for it to be registrable, the victim must be a minor, and it has to be committed by someone who isn't the parent or guardian of the victim. So that would be added back into subsection G, which would be annual registration. Those two offenses, and I don't believe they had a qualifier on them and when they were initially added. So it did have a similar qualifier. Okay. So in 2011, the legislature threw in I don't remember if it was second reading amendment, some amendment during session in a bill concerning the sex offender registry statutes, adopted an amendment to delete false imprisonment and felonious restraint from the SORNA statutes. So they were deleted as registrable offenses in 2011. The information you have outlines some of the arguments that were made for their deletion and against their deletion. And that should be right after 13-04, if it's electronic materials. in the paper materials, it's right after this bill. And Mr. Chairman, I hope that answered the questions. I'm happy to answer more, or go further if I didn't cover it.
Representative Oakley, does that help?
Go ahead.
Yep, and then Mr. Chairman, my apologies. I remembered the second part of Representative Oakley's question. The definition, that definition, and it's on page 7, it defines the term criminal offense against a minor. And that, in that definition are various offenses, including felonious restraint and false imprisonment. But that term itself, criminal offense against a minor, I do not see anywhere else in that article of statute. In essence, it's a definition for a term that isn't used. And I don't know if that definition has created confusion in the applicability or the application of these statutes, but my understanding is that's why that term, why the Attorney General's office has asked that be repealed.
Mr. Chairman?
So Senator Case.
Thank you, Mr. Chairman. I like the memos kind of clear what happened on the, but I guess when I come down to this, I'm trying to understand why this isn't kidnapping. Why isn't there another offense that it could be charged under?
So
both of these.
Mr. Fuller, did you hear that question? And can you take it?
And I don't mean just kidnapping, but is there any other offense that restraining a minor, felonious restraint and false imprisonment of a minor, why that wouldn't be a crime elsewhere? Or maybe it is, but they wanted to add the registration component to that back in 2011. So help me.
So, Mr. Chairman, Senator Case, this doesn't change the offenses themselves or what can and cannot be charged. What this bill would do would make any person who is convicted of, say, false imprisonment or felonious restraint in a case
Also register, right?
also register when the victim's a minor and the offender is not the victim's parent or guardian.
Help me out. She's got an answer.
Representative Oakley.
I don't know if I got an answer. Thank you, Mr. Chairman. So we have this disconnect on offenses that are in definitions in 301 versus 302. And so this bill makes, is this accurate, Mr. Fuller? So this bill makes it so that they're the same by adding the felonious restraint and the false imprisonment in there. I just guess if that's the case, I personally would like to go the other way and remove it from what it's in, because I cannot logically get there, to why felonious restraint is a sex offense. It literally has no sex component. I just don't understand it.
Mr. Fuller.
So, Mr. Chairman, Representative Oakley, right now in 302G, H and J, those are the subsections that say which offenses you're required to register under. This definition, this is just a definition that happens to include these offenses for a term, criminal offense against a minor. It's used nowhere else. Now, the decision as to whether these, and I believe, please correct me if I'm wrong, Katie, felonious restraint and false imprisonment, I think, are included in that federal SORNA statute. And I don't know if that's something that, the applicable office looks at in determining whether we are in substantial compliance with the federal act. But ultimately, the question of whether these two offenses should or should not be included as a registerable offense, that's the committee's and the legislature's decision to make.
So, committee, we will return to this. We're at 12 up right now, and we need to get to our noon time piece of the agenda, and we'll come back to the sex offender bill after lunch. Okay. Lunch is being delivered out in the lobby right now, committee and staff. Okay? Let's take about 5 or 7